Okay, thank you. I've got my IT guy here with me. You can see him there in the corner, a little bit of him. And we're gonna. All right, guys. We're gonna start now. And got an IT guy sitting here in case we have a problem. And so, deceased estates. Now, deceased estates and wills is basically the two things we'll be talking about. Now, the wills division we have already done. Just getting the sound closer there. My name is Advocate James Clark, and apart from being a practicing advocate for years, criminal law, civil law, general practicing advocate, it's actually nothing we don't do. I used to specialize in medical negligence, among other things. And this is one of the subjects, among others, constitutional law practice and so on, that for years I've been involved with this institution. So today we're going to talk to you guys about deceased estates. What has to happen is, on the eLeader platform, I believe that a real life webinar I conducted last year on wills is going to be made available to you. And it's very interesting. And obviously, when you look at wills and estates, you have to start at the right place, and the right place to start at is always wills. You need to know the law, the interstate law, the State Succession Act, and all of those things. You need to know that before you can move into deceased estates. Because if you don't know how wills operate and what's the law pertaining to them, how are you going to merge that into the administration and the winding up of a deceased estate? So today I'm here to do the deceased estate with you. You'll see how it goes. Maybe it's going to be a couple of these sessions. We'll see if I can get far in the time that's available to me. And we will also try and make sure that, of course, you can see me and the audio and visual is of a good standard. All right, guys, first of all, good luck with this year, 2021. It's been a difficult road for everybody in terms of what has happened in the world and in this country, and we all have to adapt. So before I start with deceased estates, I'm very involved here. I want to send a personal message and say, guys, you need to do your bit. We are not a bunch of complainers. You are becoming an advocate, you're becoming a trust-bearing advocate, or you're becoming a legal attorney, and all of them now under the Legal Practice Act is, the terminology now is you are a legal practitioner. We all have to go through these changes, but you guys really have to stand up now. You've passed your degree and you're on your way to becoming very successful. And I believe that every one of you will become successful, and that has a lot to do with doing your own thing. And one of the things that is important is that you must render your full support for this institution to get you where you have to go. You have enrolled here, you cannot do it without these people, and these people are here to help you. This specific division is under Mr. Malema, and you've got Dorcas there as his second in command, and these are good people. These are people that work day and night to bring this to you. And before you ever complain, before you ever do say anything negative, please first reach out. Talk to these people. They will always assist you. I know them personally. I don't work for this institution. I'm just a contractor that comes here from time to time out of my private practice. So it's very important for me that you understand this. It's distance learning, a lot of responsibility and a lot of research responsibility, reading responsibility, education responsibilities on you. All right, and from their side, they will assist you as far as possible. On a personal note, I think this is the best educational institution in the country. I've been contracting here from the day I became an advocate many years ago, and I must tell you that so many people have come through here and became successful attorneys, advocates later on. Now it's easier. This institution also cater now for advocates, and I'm busy drafting for 2021 the Pupil Training Manual. I hope to be finished by the end of this February, so you can branch out. These people here will always help you. So before you become negative or you complain about silly things, just make a phone call or send an email, and always reach out. These are good people. All right, guys, enough of that. Let's do deceased estates. And a lot of people are always afraid of it. Now, in your guide, I'm going to start at page 72, and I recommend that you take a pen and you have this guide in front of you. And these guys are also some of the best in the country, and Please, if there are mistakes on this guide, I'm also the contractor, independent contractor, peer instructor of the institution now, appointed by Mr. Pillay. So if you have mistakes in these guides, just send Dorcas or Mr. Malema or whoever a message, and they will get it to our quality assurance manager, and they will get it to me. So if there's mistakes in here, we fixed them. We use the reports in a positive manner. It's not a complaint, it's a contribution, because the Act changes all the time. While we were fixing this and drafting this for this year, it might have been that new legislation was passed and promulgated. By now you ought to know what these terminologies mean, and that means that things has changed. So we take everything, every problem you have, we take it and we turn it into positives. And that is your profession. You're going to have to help people. They're going to come to you with their problems. And you're going to have to turn their problems into a massive positive, and they're going to pay you the big money for that. So you can make a lot of money out of that. All right, guys, on page 72, there's an introduction there. They start out of saying to you a couple of important sections. You can work through that in your own time. Jurisdiction, death notice, will. We're going to be talking about those things. And it's just saying to you that you must render some attention to this. Then at the bottom of page 72, we are moving into general. Let's quickly have a look at what they're saying there. The administration of a deceased estate is a procedure designed to give dignity to the financial affairs of a deceased person and to provide for the orderly administration and distribution of his estate. During the administration process, the executor will deal with related matters, including maintenance, paternity, income tax, capital gains tax. That's also one that's always difficult for the guys. Estate duty, claims for and against the estate, and give effect to rights and obligations acquired and incurred by the deceased prior to the date of death. And you can go through there. You can go and read the rest. But this is what deceased estate is about. Somebody has died, and now we need a process, you might say, in terms of his last contract. If it's testate, make a note there. If there's a will, it's testate. If there's not a will, it's intestate, and that is what is important. So just make a note already there that the first thing you have to ask people, if is there a will, or if there's not a will, then you're going to have to go through the Interstate Estate Succession Act. So that is what we are talking about. And if there's a will, then of course you're gonna there's a lot of requirements, but under the presentation of wills, we talk about that. What is the requirements for a valid will? And you'll see there. You might make a note here if you haven't looked at the first clip first, that also on a certain instances nowadays, a photocopy of a will can be accepted. And there's a few loops you have to jump through, but that can be done. So we're working here with somebody that's died, they've set up a will, and now we have to listen to that last contract they've set up. And we've got to abide by that contract as far as possible. Because in South Africa, what do we have? What do we have? Freedom of testation. So we have freedom of testation. We don't really want to go and place too much obligations on people when they put up a last will and testament. But there is laws and they must be adhered to. But to a great extent, you've got freedom of testation and you've got contractual freedom. But just to give you an example, if you think about your freedom in terms of contracting, normally contracting, forget about deceased estates, then obviously the first thing you would say to me is, but hey, stop the bus. I'm not that free. I'm controlled by, for example, the National Credit Act. And so I have to draft in line with that. It's the same with deceased estates and the same with testaments. Well, there's certain things they can do and there's certain things they cannot do, but the country and the laws and kind in the world promotes freedom of testation. And that's all I'm going to say on page 71 up to page 73. Page into page 74, have your guide with you, have a pen there. If I say something that you find interesting, that explains things better, make a note of it. Right, there you'll see the administration of a estate. They've got there a funeral. This is what it's all about. And then they talk a little bit about the documents you're going to need. Just let's quickly read through them to get your mind going. Taking of instructions to administer the estate, and first consultation with family to obtain information and documentation, reporting the estate and completing your founding documentation. You're going to need that death notice in section 7, certified copies of the death certificate, the original will. And if you don't have the original will, you'll see in the first clip where we talk about wills, now it can be a photocopy, etc., etc. Of course, the inventories always. important. Why is the inventory important? It can change later, because later you might pick up that there's extra property you didn't know about, but we want to quickly determine what is the value here, what did he own, what is going on here, so we want that inventory. Undertaking a bond of security if it's applicable. We'll talk about these things in the coming hours and the coming days if that's necessary. And undertaking acceptance master's directions. There you can look at that. And you also see the section 18.3. Now, section 18.3 is under a certain a level. And we'll look at that. We'll talk about that later on. And that is where you don't have to meet all the requirements from a normal administration. Don't have to open a bank account. Don't have to file a liquidation and distribution account because the value of the estate is too small. Just remember one thing. Here's the first thing you have to write down. And I see this even with attorneys. Everybody talks about your letter of executorship. Now that's correct. But if you do a section 18.3 estate, there's no such thing like a letter of executorship. It is a letter of, yeah, I can hear you there thinking the steam is coming out of your head. It's called the letter of authority. So please just make a note there. If it's not in this guide, it will be in the first clip. But always remember, under 18.3, you're not dealing with the executor. You're dealing with somebody that has been given authority by the master to administer, wind up this small on a certain threshold. Deceased estate. So those things are important you have to look at, because when you start calling for letters and you use the wrong terminology, people don't understand you. For example, if you are sitting under a section 18.3 and you're talking about executors, people might think, but there's a lot of value in this estate, because that's the implication of having an executor. And that's not to say that the executor cannot appoint it. I must say that the master has a discretion. If they wish on an 18.3, they appoint the executor, they can. But normally it's no problem. It's going to be a letter of authority, 18.3, and a normal one above the threshold, it's going to be a letter of executorship. So make a note there. It's not in here, something I'm thinking of while I'm going through the pages here. Nomination for the appointment of executor, certified copies of the nominee's identity documentation, declaration of marriage, if he's married, certified copies of that. Certified copy of the antenuptial contract, please have a look at that. And always remember that there could be calculations. What I'm going to make a note here. When you see antenuptial contract, immediately it must spark accrual. They have an antenuptial contract. Are they married inside accrual or without it? So these are things you have to look at. So do you see what's happening? We're going through a list here, and immediately it's triggering things that has to be considered and things that has to be done. And then, of course, you have your affidavit in terms of section 22. We'll talk about that later. And then, of course, the covering letter to the master in which you report this deceased estate. Now, before I go further, as far as possible, this must be acquired in your first consultation. When you get an instruction to administer deceased estate, look at this listing. And when the executor is sitting in front of you, you might be the attorney appointment on behalf of the executor to administer. So you will become what? What is the legal terminology? You will be the agent of the executor. The executor will still be the responsible person for this. But it can be that you, an attorney or an advocate or somebody else, but in our profession is appointed as executor, and then of course you are liable. So at your first consultation, whoever is sitting in front of you, and when you go through that testament, call upon these documents, see who's the executors, take note of who's the heirs, and make certain. And then, of course, copies, and do not forget the certification of the copies. Very important. Always certify your copies. There in my office in the front desk, up to Sunday night, it's been hectic in terms of firearm licenses and nesting. And believe you, photocopies, certification. All right, let's go on. Still on page 74, they talk about obtaining the letters of executorship. It's always nice in a guide to have this introduction, because it actually sums up where you're going to start, what all we're going to be talking about, and to the end. So this at the end, this in the guide actually becomes your headings through the guide. Notice to creditors is going to be very important. And then you will see they're opening a state banking account. If it's not the 18.3, remember that. And then gathering information, valuations, balance certificates, realization of assets. There's a lot of things you have to do. Drafting of the liquidation distribution account. And let's stop the bus there. This is the heart attack of all deceased estates. I mean, we can do everything, but the moment we talk about the liquidation distribution account, people fall out of the bus, if I might put it like that. And so this is something we're going to have to spend time on, and depending on how far we get, you can talk to Mr. Malema. Actually, I think you'll talk to Dorcas, he's second in command. I am doing a practical presentation of deceased again a little bit late in the year. I don't know, maybe it's after you guys going to be finished. I can't remember the date, and then, but it doesn't matter. You can actually then again enroll there, and there we will also spend much more time explaining the liquidation distribution account, because it's difficult. There's a specific way of doing it, and you need to understand what's going on. Then there's a lot of mathematics involved in it, and a lot of percentages, and a lot of legislation. Then we're going to move on to the submission of the liquidation and the distribution account. Then the queries by the master, attend to queries by the master. Inspection period. Hey, by the way, do you have your pen in your hand? Yeah, how long is the inspection period? Yeah, you've got that right. It is 21 days. 21 days. You can write it in there now. If you have a pen, you can write it. It's 21 days. Got to lay for 21 days. And anybody that wants to object, can go object. But there's a lot of legislation around it. Where is it laying? At what places we can get it to be observed and inspected? So there we're going to have to talk about that too. Then you have to attend to the objections. Finalization of the aspiration expiry and inspection period is important. Final requirements account to master, and then apply for a discharge. Who applies for the discharge? Only the executor. Or then, of course, under the 18.3, it's not necessary because you won't have a liquidation distribution account. And then filing your notices, your filing notice with the master. Now, that filing notice means that everybody's happy. Apply for the discharge as executor. Your agent, if you're the agent for an executor, attorney or person on the street is appointed to represent you because you know what you're doing, then yes, the executor stays liable. The executor is liable. Are you listening to me? The executor will go to jail for fraud and all of those things. So let us not underestimate what's happening here, especially in big deceased estates that got a lot of value in them. So please be careful. Now let's talk about that for a minute. When you are an executor, you must be very strict. Very strict. I get letters daily, and I'm involved in cases daily where I have to give advice. I'm busy with 2 cases currently as I'm sitting here that came in yesterday, where I have to advise on the road forward in these things and the necessary court applications to make things to get things going. So please, if you're an executor, nobody intimidates you. Nobody manipulates you, because it's all family. And that can happen. And you're very strict in terms of how you do this. And if you appoint an agent, and if you are the agent, the executor doesn't bully you. And if you are the executor and you have an agent, you double check everything that agent is doing. Regardless of the fact whether it's advocate or attorney, it doesn't matter. You make certain, especially when it comes to charging fees, make certain that the fees are in line with the Act. And except if you have agreed on a fee, if a fee was not stipulated because you've got different fees, make a note there. You've got your master's fee, the normal master's fee on the value, the gross value is 3.5% of the gross value of the deceased estate. But after the date of death, everything you accrue that you bring in as an executor is 6%. So there's a lot of calculations. There's big room for fraud and theft in deceased estates, and it's jail going time. So please, guys, be very cautious of that. Moving on, that's it. That's basically it. That's the whole guide. That's the headings, the flow of the whole guide. So now that you know what we're going to be doing, and it's not even in the index, it's a practical guideline. The steps are actually set out, and if I'm not correct, we're going to be looking over and over at this. I know when I do this for support staff, we do it 4 or 5 times over and over to make certain people understand it, because people literally get negative, especially when it comes to what? That liquidation and distribution account. Right, there on page 75, discussion of the administration process, taking of instructions to administer estate. You can go and look at that. I've never told you what to do. We already said it. They talk about a first consultation with family members. Make certain you see everybody. The reason for this is, you can go and read. I don't want to read. I want to talk to you as I see the headings. And you go and read, and there's a lot of stuff in there. But when you talk with the family members the first time, somebody has died, there's a will, most of the heirs will be, most of the family members will be there. This is most probably the last time you're going to get them all together at once. whether it's a conference meeting or in your office. This is actually the best opportunity is that first meeting to be able to get all the documentation and all the things that's necessary. So if you are going to be practicing deceased estates, etc., make certain that you build your own pro forma in terms of what is required, what do you want to do when you take on such a client, so that when you walk into a boardroom or you're on a telephone conference or a webinar conference or whatever they call these things, that you can immediately say, I need this, I need this, and I need this, and you don't look like an idiot. I've sat as an advocate into some of these meetings where attorney wants my presence when complicated deceased estates comes in, and I can see this attorney is not prepared, he does not have a performer, he does not have a checklist, and I can see down the line that after this first meeting, he's going to be phoning people a million times, and they're going to start get frustrating with them. Now, if you want to see a running fight, it is deceased estates. They phone you 1,000 times a day to inquire how far you are, because they want to inherit, obviously. That passion, that sorrow very quickly makes room for who's going to inherit what. Before I move on, remember in this first meeting, remember when people come to you, you have to be sympathetic. Now, it's interesting that I have to say that. I should not, as a human, actually should say this to you, teach you this, but they really, I've seen people that's got no sympathy. They rude with the people walking to the office, and those people are still recovering from the shock of what has happened. So please, you have to be sympathetic. You have to understand they've lost a dear one, and you have to deal with that in the appropriate manner. And in any event, under the code of conduct nowadays that's going around, you can get reported for if your conduct is inappropriate, and we don't want that, right? And of course, you're a human, you care, right? It's not just about making money. You're going to assist these people. They must be a part of you that understand their pain. Going on, page 76, paragraph 223, reporting the estate and obtaining letters of executorship. This is important. The founding documents to report the estate must be completed and signed by the surviving spouse, nearest relative or connection, and the prescribed documents to obtain letters of executorship must be completed and signed by your nominated executor and submitted to the master of the High Court having jurisdiction. So now that we're reading about the executor and the letters of executor, there it's coming. Remember one thing, you are not the executor until you're appointed by the master as the executor. Neither are you this authority person under the 18.3 deceased estate. You must be very careful to start spending money or giving things away before you have your official appointment. Why am I saying that? Because it's theft, it's fraud. You don't have legal capacity to act as an executor until the master appoints you. And you never know. There might be somebody out there that wants to oppose your appointment, and you're already starting to giving things back, allowing people to the heirs, allowing people into the house to take things, making payments out, and you can get into serious, serious trouble. Don't do it. Stand strong as the executor, and if you are the agent of the executor, make certain that the mandate you signed with the executor is strict in the sense that you are authorized to 100% comply with legislation, so that this executor cannot later come to you and say, okay, I know what I said, but we need to just give these people R1,000. They're phoning me every day. I had a case like that 2-3 weeks ago. Somebody phoned me for a legal opinion on that, a little bit more than 2-3 weeks ago, actually, and I said, no, you don't do that. So that is important. So wait until you're appointed as an executor before you move, and make certain that if you appoint an agent, if you're the attorney or if you're the executor, you appoint an agent, that they know what they're doing and getting those letters as fast as possible to the master for that appointment. Because if there's a delay, it's a family fight. Then, of course, as soon as this is going on and we're starting with the process, you have to issue your notice to creditors. You've got to inform them of the death, and then you will start negotiating with them. They will send you the settling balances. And what's nice about the deceased estate, if you say to people, the deceased estate, please remember this, make a note there. You can negotiate. You say, okay, the settlement agreement is 3,000 Rand, but can we settle for a full and final payment on 2,150 Rand? So those are things you can do. And a lot of the people accept it because they know that actually the deceased estate can go on for quite a while before the payments are made. So you can actually say to them, guys, we can settle this quickly, you can get quickly. How about we settle this for 1,000 Rand less or 1,000,000 Rand less? I don't know what the outstanding debts is out there. So these are the things you have to learn. And opening your bank account, This is important. Let's quickly read it so that you can, with a highlighter pen, I hope you've got a highlighter pen there, yellow or orange or blue or something. Just make a note there that when you open the executor's account, you open it if there, as soon as an executor has money in excess of 1,000 Rand. You must open a check account at a bank in the Republic of South Africa. So you can go through the rest of there, what you need to take to the bank. Obviously, your letter of executorship. But the moment that you have more than 1,000 Rand cash or whatever the situation might be, if there is 10, 40,000 Rand, because you've got to close all these bank accounts, these credit cards, everything. So most probably you'll have way more than that. So that is important to also look at. Remember again, under Section 8.3, you don't open a bank account. All right. Gathering of information, valuation, balance certificates, realization of assets, go through that. That is where you start valuating assets. Your agent, or if you're executive doing it yourself, validate a car, validate furniture if you can, that expensive painting against the wall, and then you got to go through that. Let's just read about it, because it does talk about something that's very important, and that is advertising. So let's just have a look at it. The executor must determine value and validate the asset and liabilities. The initial information will be obtained from the family, and the post address to the deceased, last address, an important source of information. So remember, when you're in that first consultation, make certain that somebody is recovering his post from his last postal address, if you have something like that. And then one of the family members must do it and always send it on to you, because you've got to change that address, make them send it to you, etc., etc. That's very important. That's very important, because there you pick up a lot of information. And if it's internet-based electronic communications, then you're going to have to take control of that facilities electronically, and start locking them down and letting those people know. But you keep them open for a while as your net bank statements are coming through, and your Absa bank statements, and your municipality accounts, rates and taxes and levies, all of those things. This is a source of information. Because you don't want to get to, I'm almost finished with winding up the liquidation and distribution account, and suddenly 7 to 10 new creditors jump up. You don't want that. Go through there. They talk about, in terms of Section 29, an advert is placed in a local newspaper, Government Gazette, advising creditors of the death. Please, you got to do this as soon as possible, because that also helps people. You will be surprised. I've also dealt with a case like that about 2-3 years ago. You'll be surprised. We were looking for a sister that was lost. And actually 2 brothers were lying to us. And by investigation, the attorney of record found out, but you guys have a sister. They want to take the house for themselves. Can you believe that? All the cases I've done through the years. And we placed an advertisement. And about 2 weeks later, the phone rings and says, hey, there's a sister here. So we found those 2 clients of yours, 2 brothers. You got a sister. Yeah, but she's not talking to us. Nonsense. He died without a testament. What does that mean? She inherits equally. Yeah, you got it right. There was no will, no written will. So, yeah, we got them all into the boardroom, and that was tense. And then later on, they all hugged and kissed and cried, and okay, that worked out. Let's move on. Right, going here into 228 on page 77. Drafting the liquidation distribution account. Now we got to be careful. We've got to go through this. The assets and liabilities of the deceased must be valued and validated. And thereafter, the executor must draw a liquidation distribution account in terms of Regulations 5, recording details of the assets and liabilities of the deceased at date of death. 1 second, please. Justin, just go to Merlin's office, if she's there. Ask her for a bottle of water. Otherwise, I'm going to lose my voice here. And if Merlin doesn't have a bottle of water, you can then ask Dorcas. I know Merlin and them have got a fridge there. All right, that's my IT guy, chasing him around here. IT guy. He's got to run around here for a little bit of water. Right, so there's the liquidation distribution account. We've got to set it up. You've got to get us valuations. And remember, on your first inventory, it can change later. Don't worry about change. It can change. You're not bound to the first projected values. You just want to say, okay, and for example, let's take immovable property. One place where you can get a value that most certainly will change later is the municipality of a property. You can put it in there. You can put it in later when you do an agent's valuation. Maybe it doubles, you know, something like that. So it can change. It's not the end of the world. As long as you get to the right amount when you get to the liquidation distribution account. So those things are important. Have a look at that. Then they say the account must be submitted to the master within 6 months of the grant of letter of executorship. And so they go on. So they're jumping the gun a bit here. If you cannot do it within 6 months, then just ask for extension of time. Come right down there. Take your pen, write down there. If you cannot do it in 6 months, then you can have an extension of time, and you will not believe how many people go over 6 months, and some people even get away with it. They don't even ask for extension of time. They just follow the process way over the time. We put it in, don't do it. Don't do it. There's just one official sitting in the Master of the High Court. He wants to do his work 150% correct, and he takes you on. All right, there can be penalties, there can be nasty things that can happen there. So you've got 6 months to do that. So if you get to 4 or 5 months, you say, I'm not going to be able to do this, just ask to make extension. And by the way, if you ask to make extension and you have filed it with them and they don't come back to you, don't worry about that too much. Just keep on going. That people that asked me for an opinion a couple of weeks ago, that was one of their problems. They had a problem for winding up, for finishing up. And the master in Nelspruit wasn't coming back to them. And I said, well, all right, then we have to deal with that in another way. But in this case, then obviously you just keep going. As long as you filed it, it's their obligation, the State Department, to reply to you. Just keep on going, but file it. Do not file it. All right, are you okay? All right. Queries by the master, what do we do? You submit your work and all of that. And then you have queries by the master. Upon submission of the liquidation distribution account, the master will examine the account as to form and content. He may raise queries and call for a voucher to substantiate any or all of the items appearing in the account, and so it goes. If he's of the opinion that the account is incorrect or that it does not comply with Regulation 5, he will issue a preliminary directive document known as a query sheet, and then you have to then see what is on it, and you have to reply and fix and get back to them. I have seen one thing. Sometimes they just write on that sheet. And I have seen one thing, that you cannot always read what they are writing. So then you have to go back to them. I know there was one that I couldn't read, and we all sat around the table to figure this out. And eventually somebody says, no, man, I think that word means that. And luckily we got it right. So these are the things that happen, and they waste a lot of time. So yes, then of course, and you've got to fix that. Then they fast tracking it here. Then we're going into the inspection period. Look at that. There's the 21 days. I told you. So once the master is satisfied that the account has been correctly drawn, then we will have the account lay open for 21 days. And in this period, there can be objections, etc., etc. Now, let me give you a little bit of advice. When you are the administrator, now the administrator of the deceased estate can either be the agent or the executor. It depends on the executor if they want to appoint an agent. Most of them do if they're not attorneys. If you keep in constant control with the heirs, and if you're the agent with the executor through her to the heirs, then most of the time, they know what's happening, and there will be no objection. So please, one thing with deceased estates, if you're going to do this, is communication. It's family business. People fight and rip each other's hair out about these things. They argue and they fight into court about why did you get a Ferrari and I the Porsche, things like that. So please, communication is paramount for peace and tranquility in getting this up to your inspection period, and not having frivolous objections to what you've done in that document. So this is just one of the things that can help. It's not a guarantee. But those of you out there that has been administrators becoming attorneys now and actually saying to me, I've been doing this for years, but now suddenly I'm an attorney, you'll know what I'm talking about. So we have that. Go through that. Please read through that. We only have so much time online, so I need to start picking up speed here. And then we go to finalization of the administration after expiry of the inspection period. After the account is laid for inspection free from objection, obviously, or after any objection has been disposed of in a prescribed manner in the master's discretion, is not taken on review or appeal. See what can happen. The executor shall proceed to finalize the administration by forthwith paying creditors, etc., etc. Now, important there is cash amounts must be distributed within 2 months of the estate becoming distributable. I am suddenly thinking of something. Please make a note there. No checks, right? Checks are gone. Checks are not legal in South Africa anymore. And in this guide, you might pick that still up. It's possible. You understand what I'm saying? So what I want you to do is just remember that you can't work with checks anymore. Checks are gone. But obviously, if you have a running estate that's very old, you still have to keep those checks until this is winded up and for a period always also afterwards. But all new estates coming in will not have checks. Checks are gone. Checks are gone. Doesn't matter if you do attorney's bookkeeping and all of those things, conveyancing, all those subjects, there might still be mistakes in that guide. It's very possible. Remember, checks are gone. So I just thought of that while I'm looking at the cash here. Then final requirements. After having attended to the payments and transfer of the assets in terms of the account, the executor must account to the master, confirming and substantiating that the heirs and creditors have been paid. And it's not this easy. There's agreements you have to engage in. There's documentation that has to be done. They're just fast tracking in before we get into the nitty-gritty of this. So the executor is then entitled to be paid his fee unless early payments has been approved in writing by the master. Now, the thing I want to say here is, remember, it's 3.5% on the gross value of your estate and 6% on everything that you've brought in after the death of the deceased. So a lot of people don't take that 6%. A lot of people don't know about that 6%. Everybody's, yeah, we get 3.5% or less, or whatever has been agreed. You know, agreed with the people. Some will say, so and so will be my executor, and they will get 1.5%. And then, of course, the 3.5% is also susceptible to being shared between maybe a referral attorney and in terms of the Legal Practice Act. I almost said Attorneys Act. That's totally redundant. Let me make a quick, nothing to do with this. Attorneys Act has been totally repealed. I looked at that again today when I was busy with your examinations in March. Please, Attorneys Act is been totally repealed by the Legal Practice Act. But there is a section in there, I think it's 34, 46, I can't remember, where attorneys can share fees, not advocates, attorneys. Filing notice. That filing notice is very important. If a filing notice is not issued, the deceased estate is not winded up, it's open. So it's very important that you make certain you secure that from the master, and that will only be issued to you after you have sent in your liquidation and distribution account and for your discharge, and you have completed what? You've completed what? At the end, at the total end of the liquidation distribution account, your discharge, your certificate, and you have signed a couple of statements you're making there to say that you have done everything correct and you are finished. All right, that's good. So that was quickly that. That's great. That's great. We're getting an understanding of what's happening here. We are talking from the beginning and the end very quickly before we're going to get into certain aspects in detail. The most important parties involved in the administration of the deceased estate is logically the master of the High Court. Now, if you go to page 79, they've got a supervisory function there, advisory function, administrative and discretionary function. It's got discretion in certain fields. In certain fields, it does not have a discretion. Even if it's an administrative application, it has to go through the High Court, secure a court order, and come back. Even if it's an ex parte application, and then in other places they have discretions, and then of course it's judicial function, etc., etc. And then of course you can go through that in your own time. There is the executor. The master issues letters of executor on page 80 to the nominated executor, whether the appointment be by will or dative, who is then empowered to administer the estate of deceased. I don't want to talk too much about these things. They're logical. I just want to say to you, if you're an executor, you have a very responsible task in front of you. And please, you cannot, it's illegal, it's unlawful, you'll go to jail. You cannot illegally conspire with heirs for a benefit towards yourself under a deceased estate if you are the executor. Go read up on that. You're not allowed to do that. Everything has to be legal. So you can go through executorship there. Very important, you're going to have to look at who's disqualified as executor to make certain that the executor is legally appointed. And there's a couple of questions you have to ask also. If you're going to be the agent and an executor walks in and appoints you the attorney, the agent, you're going to say, all right, so I'm going to now ask the master to appoint you as executor. Do you have a criminal record? Blah, blah, blah. All of these things. There's a whole list of those things. And you're going to have to make certain under the paragraphs, and it's in here, we'll get to that, if this person actually can be appointed an executor. Maybe there's a reason they can't. So just have a look at all those things. Be honest, have integrity, and make certain that you move as fast as possible. And on the deceased estates, the guys listening would say, yeah, sure. Well, I agree with you. It's never fast. Going on to the receiver of revenue, go and look at there, at capital gains tax and all of those things, the Estate Duty Act. You can make a note already there. What is estate duty tax? 20%. So just right now, there you have in your mind already, it's 20%. But there's other percentages, other capital gains tax, and the way that operate, you're going to have to look at that. Moving on to the surviving spouse and the beneficiaries. Those are the people that's most probably going to make your life hell. And if you do your work properly and you communicate ongoing, unfortunately you have to, then it will be a little bit better, but it won't be a guarantee. These persons naturally have an interest in the estate of the deceased, and the sensible executive will maintain a sound relationship and communicate with the family members and beneficiary administration process. And the more they're going to inherit, the harder it is. But then again, I've seen people create hell over 5,000 Rand because they have nothing. And then 5,000 Rand is a lot of money. But these are the things that you're going to have to look at. And of course, if it's 5,000 Rand only 5,000 Rand, there's nothing else, then it will be an 18-3 situation. Taking instructions to administer the estate. I'm not going to talk about that. I've already told you what to do. Look at everything here. Get him in there. The first time you get them all together is going to be the only time you get them all together. After that, it's going to be very difficult. And before they arrive there, send out your pro forma, phone them, make certain that they have everything you need there. Now I want to say something interesting. I want to give you a bit of advice, if I may. It's not a good idea to certify your own copies. With that, I mean not your copies, but I mean if you're going to be the agent, the attorney representing them, it could be a good idea to rather get an independent commissioner to certify copies for you. Just telling you, they have been involved in cases in the past where this has become a conflict. Thank you very much. My water has arrived. This has been a conflict of interest situation. And I've also caught people on dates. When I do cases, I've caught people at dates where the dates were done after a certain other date was done. And when I compare it, I see it cannot possibly be. It amounts to misrepresentation. It amounts from fraud and a violation of the Commission of Oaths Act. So please, just in passing, assisting you there. As far as possible, tell them to stop off at the local police station, or if you are in the city and you have a relationship with an attorney firm, a couple of officers from you, like we always do, then do that. You will know, as I'm an advocate, the first thing they teach you when you become an advocate in chambers with the official bars, don't have the advocate sitting beside you authenticate or act as a commissioner of oaths for you. Later on, it can become tense if they called as a witness, and it's a conflict of interest. Don't do it. All right, going on. Spent too much time on that already. Let me just get my page numbers here. They're right here. They're running right because I've got a page in a certain manner. First consultation, I'm going to leave that up to you. I think I've said enough about it. Read through it. And then the reporting of the estate. I think I'm going to spend time on that just a little bit again. We've done it now there. You need what the documents are, but I think we need to talk a little bit more about it to make you comfortable. Reporting the estate is an important step in the administration process, and proper and strict compliance must be given to the completion of the founding documents, which must be submitted to the master. The terminology we're using here, founding documents, just basically means that's the first bunch of documents you're going to send to the master of the High Court. And for example, if you don't have the right identity documents in there, and remember, you need a death notice and a certificate of death. So just be careful of that. There are two different things. You can see that there in Section 7 of the Act. Now, if you make a mistake with this reporting, it's not going to get reported. They're going to send it back and say, we're not doing it. All the documents are not here. We cannot do it. So be careful of that. And there they talk about a death notice. Death notice is a prescribed form J294, which appears in Schedule 1 of the regulations. The death notice contains the personal details of the deceased. It must be completed by the surviving spouse. Take your highlighter pen or whatever, mark that. And failing whom, relative or any person who's connected and who is likely to have knowledge of the deceased person details. That's your death notice. Now, what is your death certificate?
If the person signing the death notice was not present at death or did not identify the deceased after death, then a certified copy of this certificate must be lodged with the master together with other reporting documents. It is the master's current practice to require a certified copy of the death certificate with the reporting documents. Actually, as a matter of fact, if you can, get everything to them. The original will, you must always have the original will. We know now photocopies has to be used, and there's a certain process you have to go through, then you can use it. And please, we're going to be talking, I'm going to be talking at the end of the year on a private webinar a lot about the original will in terms of the Electronic and Communications Act. And there's a lot of court cases. When a person dies, they can't find his will. They go on his laptop, they find his will. With a court of ordered, yes, it's a will. So there's a process you have to follow, but your first priority is where's the original will. And if they have a photocopy, then you're going to have to go through the certain applications, but it can be done now. And if nobody opposes this, that's the problem. If nobody opposes it, then it will be fine, all right. Then that first inventory on your form J243, in terms of section 9, provisional inventory, underline provisional. You just walked in, everybody's telling you stuff. And you want to report this thing right now. That's why it's called a provisional inventory. It's not a final one. Must be lodged with the master when the estate is reported. The inventory reflects the estimated gross value of the known assets of deceased estate, the date of death, and then they tell you the amount of securities and they walk you through that. Have a look at that. And there is the 83. Please mark it. Remember the threshold we spoke about? So any deceased estates under 250,000 rand in the total value, that will be letters of authority. And you don't have to need to open a bank account. There's a whole list of things you don't have to need. But most importantly, you don't have to need a bank account coupled with the fact you don't have to open the liquidation and distribution account. That's, if you ask me, the most important one, because then there's a couple of forms you have to fill in, affidavit stuff, and you run it through. Then the acceptance of trust as an executor. Before I even look at what I've done here, even if I appoint somebody as the executor, there's no obligation on them to become the executor. So it's a choice. So you must always ask the person, do you want to be the executor? Are you sure you're up for that? And then they will tell you yes or no and whatever the situation is. And then, of course, the acceptance of the trust as executor, of trust as executor, is not regulated form but a document created by a master, which in essence deals with the issue raised by Section 23 of the Estates Act, so that the master can obtain details to exercise his discretion as to whether or not to suspend security. The security issues we'll be talking a lot about, but I've already spoken with it in the first clip. There we talk about the drafting of a will, and there we deal with the security. We waive the security. You say it's not necessary. But under certain circumstances, it will still be required regardless of what you're saying. So be careful. Go and look at what we're doing there. But that's what that is about. So whether it was waived or not, if there's not a waiver, if the will does not waive security, you might have a problem. You're going to have to give security. Written application must be made for appointment of every executor when a testamentary deed or assumed acceptance of trust as executor. The personal particulars of nominated executor must be completed in Part A of the form. The name of the executor's agent, who may be an attorney, who will assist the family with the administration, must be completed in Part B. And there you have it. Work through that. So that the acceptance of trust as executor must be done correctly. So you've got to go through that. Luckily, that form leads you through it, and those letters lead through the act, leads you through that. And there you can see that if you're going to appoint an agent, it must be reported to the master also. Next of kin affidavit and nomination by heirs. This is a document you must also put up. Where there is no will or where the will does not nominate an executor, it will be necessary for a master to make a dative appointment. The meaning of dative, it's not done by the deceased, it's done by the master. In order to do this, the master requires, in addition to the usual reporting documents, a certified copy of the marriage certificate and affidavit of the next of kin of the deceased, as well as nominations from the surviving spouse, heirs or creditors nominating a person executor dative. One must be mindful of the provisions furnishing of security. Yes, you've got to look at that. Who can be appointed as executor, who's qualified, who's not qualified. If he's a criminal, he's got a criminal record, he's not qualified under certain circumstances. And we're nominating a person to be appointed as executor. So work through that, and then see what that paragraph is saying. And there you can see one of them they're giving when there is no will or a class of persons has been nominated as heirs in the will, for example, to my grandchildren. Oh, by the way, when we do grandchildren, that's a class of people. Now, take note of that, take cognizance of that, because later on, we're going to be talking about the class impact more on what the legislation is saying. So they're helping you out a little bit, go through that and work through that paragraph in your own time. Then the antenuptial contract, we spoke about it a little bit earlier, where the deceased was married out of contract, get a certified copy, attach it, and also there they talk. There you can see, you must determine whether or not accrual or accrual system applies. We've already mentioned it, so you know about it, and here it is. So, an example of a covering letter, and this is always great when we give you that, because I've been talking, you're like, yeah, all right, I get it, but this letter. Here's an example. There you have it. That is John Adam Smith. Your letter will be the attorney's letterhead or whatever letterhead you're going to be using as an agent, whatever the situation might be there. You address it to the Master of High Court, and then you have to put your heading in there. And then there's the letter, death notice, inventory, original will, nomination for appointment of executor, and together with certified copies of the nominee's ID documents, undertaking and acceptance. And when you page, it goes on, it ends there with the nominated executor's identity document. And you can see that was the Beers & Oripas Incorporated attorneys that set that up. And there you have it. And there you will say, it's important, please look at this letter. You must have authority to be appointed. So you must have a fully fledged mandate that gives you a lot of authority if you're the agent. But look at that paragraph at the end. We have been requested, you can say instructed to assist the nominated executor of the administration of Buffman's estate who will act as his agent. And then the master is requested to grant a letter of access as soon as possible. Don't forget those paragraphs. They are quite important. All right. So now we're up to that. Let me just oil the throat here a little bit. Now, if you are passed beyond this, you have to wait for the reference letter, the letter with the reference number of the deceased estate. Now, please make a note there before I go further, because this is now my mind. It has to come out verbally so that you can hear it. This is the only letter you're going to write. Let's page back. You'll see there that you don't have the reference number yet. Master's reference numbers, new estate, 2080. Do you see it? You don't have a reference letter yet. I've been asked so many times, where do I get a reference letter? You're not getting it. You'll only get it after this letter. And then every letter, every email you ever write again, until this deceased estate is finally winded up, you have to use that reference letter, the reference number. So please don't forget it. Make a note there that the moment you get it, that you have to do that. That is so important, because that's going to be the number you're going to utilize to wind this up. It doesn't matter if it's a letter to your creditors or whatever the situation is. All right, they talk about on page 86 about steps to be taken while waiting for the letters of executorship to be issued. It may take a while before the letters of executors are issued. In the meantime, valuable time can be saved by doing the following. Personal details. Obtain the personal details of the heirs, etc., etc. Yes and no. No, because you should have done it in the first consultation. If you've not done it, then obviously you have to follow this path. I cannot overemphasize the first consultation's effectiveness on how you do that, because after that first consultation, the people disappear, and sometimes you cannot make contact with them. You even have people flying in from overseas for this first consultation, and then they fly back, and you're going to struggle getting it. So yeah, good. I hear what I'm saying here, but it's a no-no. But if you've made a mistake, maybe you forget to ask something from somebody, then obviously I'll agree with this. But you must do this at the first consultation as far as possible. Documentation, ensure the following documentation: checkbooks, statements. No checkbooks anymore. It's over. We don't have checks in South Africa anymore as from last year. Investment certificates, insurance policies. Make a note there. When you ask for insurance policies, it's best to ask for all of them. But you know that the beneficiary of an insurance policy determines whether it's going to be part and parcel of the deceased estate. If the deceased estate is the beneficiary of insurance policy, then yes, that money goes on in there and it's part and parcel of the administration. But if some individual by name is the beneficiary of some kind of policy, usually it won't be insurance policy, it will be some kind of life policy most probably. Then of course it's paid out to that person directly. It's got nothing to do with the winding up of the deceased estate. Make a note there. Although they say insurance policy, my mind already in general goes to policies, and this is one of the things. Now under wills, you will see, we teach you that when you put up a new will for somebody, always ask them, can you afford a policy where the deceased estate is the beneficiary? So to cover expenses, you don't have that thing where people have to pay in or you're stuck with an insolvent deceased estate. So that's the reasons behind it. There's a lot of things to talk about that. You can go through that in your own time. Write letters to interested parties. A lot of correspondence you're going to have to now engage in. A lot of people that will be interest party. The first interest parties I can think about is your creditors. But you're going to have to gather that information, look at a post, go through his email, excuse you, site, or whatever the situation is. You're going to have to look at that. Most probably that after your first consultation, you will write a nice letter to all the heirs. We've been appointed, we had a first consultation with the heirs, and we're going to be doing our best for you. And if you have any inquiries, do not hesitate to contact us. And then if you still need stuff, I suppose you'll ask you there too. But most probably your first letters will be to the heirs. And then, of course, to other people. Letters enclosing a certified copy of the death certificate should be written to all interested parties, especially your creditors, SARS, and all of those people. Don't write your letters to a person you're writing a letter to for the first time without attaching the death certificate. You have to prove to creditors he's dead. If you're just going to inform people regularly also that he's dead, then maybe on the request of the executor, if you're the agent, always contemplate attaching a death certificate to it. Because one of the questions that's going to come back to you and waste your time is, how did he die? If you attach the certificate, the death certificate, usually they've got a cause of death on it there. Especially in the times we are living with. If you think about COVID-19 and all of those things. And then you're going to also proceed valuations. You can proceed with valuations actually as soon as possible. The moment the executor is appointed, and whether you're the agent or the executor, the moment that letter appoints that executor as executor, for the first time, now listen to what I'm saying to you. He wants you to report it. Your first instruction is to report the deceased estate. Now he's saying you're the agent. Are you really the agent? When do you officially become the agent? When he is appointed as executor. And in the past, I've taken the instruction, and I've sat with attorneys taking the instruction. But you might want to consider also putting a clause in your mandate that says, we agree to this. I am the appointed guy, everything when they first walk into your office. But this appointment will only be officially enforced on the date, or as from the date the master has appointed the executor. Think about it. He does not have authority before he's appointed, but he's already gone to you and you're the agent. This is something. Now I'm talking to you. What is this subject called? I'm talking to you about contract law. That's where it falls. But obviously it pertains here. The executor again, or the master's representative, this is the guy with the authority on the 18.3, right there 18.3. You'll see on the top of the letter is a letter of authority, but they call it the master's representative. Don't muggle this up when you talk to people. There's a big difference between a master's representative and a master's appointed executor. And I talk there in general, there are various statutory provisions contained in the Estate Act relating to the appointment of executors and a master's representative. It must be borne in mind that when an attorney is appointed as executor in an estate, he acts in that capacity and not as an attorney. I'm going to stop there. Remember that you are, if you are the representative, that's what you are. If you are the executor, that's what you are. And if you are the agent, that is what you are. Now, the agent is actually he's appointed as an agent in his capacity as an attorney. It differs a little bit from representative executor. Then you cannot stand up and say, hey, but I'm an attorney. But as an agent, surely you can do that. All right. Appointment of an interim curator. Now, this is interesting. This is interesting. I just want to look at something in this guide. I'm not too sure. We might have to, oh yes, it's wrong. It might be wrong. Look there on page 88. I want to show you something. What is an interim curator? There may be a delay in granting the letters of executors. In some instances, it may be necessary for someone to be appointed to take the estate into their custody in order to avoid loss or prejudice to the estate. For example, a business or a farm may need to manage until such time as the executor has been appointed. For this reason, Section 12 makes provision for appointment of interim curator, can take the estate assets into his custody until such time as the executor is appointed to liquidate and distribute the estate. Before the master will appoint a person as interim curator, such person will have to lodge security with the master, underline that, for an amount determined by the master. The interim curator may, if specifically authorized by master, do the following. All right, the interim curator is great. But now, what do we pay the interim curator? Go to the last paragraph. The interim curator is entitled to a fee of 1/8% on the gross value of the estate under the custody on the date upon which the letters of executor are granted. Let me explain to you. First of all, there's a mistake here. It's not 1/8%. It's 1/8%. So it's not percentage. You understand what I'm saying to you? Here they have a percentage sign. Go and Google it. You can argue with me if you want to. I'm open for that. But according to me, it's not 1/8%. It's 1/8% of what? The gross value of the estate on the date on that granting of a executor letter. And that's the date. This is calculated, and that's the fee that's paid to the interim curator. I think the percentage sign is wrong. According to me, it's not percentage. It's 1/8%. And I don't know if that's going to amount to the same. We did a calculation on it the other day, but go and look at that. And right there, I'm telling you now to research it as your facilitator. So now you have to do it. And if you ask in an exam, you cannot come back and say, hey, there's a mistake in the book, or there's not a mistake in the book. I know in some of my guides, I've corrected it. I don't agree with this. So you're going to have to come and look at that. All right. So that's very interesting. And go and read up on that. So there you have an interim situation. It has to have security, and the master will appoint, and there's only certain things they can do. All right, let's move on. Great. So we have now fixed that. That could be a problem. Going on to page 89, nomination of the executor. The issuing of the letters of executorship by a master, extremely important, since Section 13 provides that no person may liquidate or distribute the estate of a deceased person without having been issued with such letter of executorship. Do you see it? I'm not even going to talk about it further. This is what I'm saying from the beginning. You are nobody in the sense of an executorship until the date on that letter that the master has appointed you. So please be careful with that. The master may appoint an executor in various ways. One must distinguish between an executor testamentary, nominated by a will. This is the difference between testamentary and dative, all right? And an executor dative, where the person is not nominated by the will, and a final decision will be with the master. So testament of the executor is the deceased says, Joe will be my executor. And he said nothing about who must be executor. And then usually it will be the surviving spouse, or when you look at this descendants and ascendants and co-descendants, if you want to, I don't even a word like that exists, it will be the closest relative. So that is what that's about. So please, dative means that, and testamentary appointment means that. Then I talk again about a 250,000 of the 18 I'm not going to talk about that. We've done quite a bit of them, and if you know what you're doing, it goes so fast. The only place that you've been held up is at the master, but it goes very fast. You can go through that in your own time. They talk about a testamentary executor there. A testamentary executor is appointed by the master. I'm not going to repeat myself now, but I am going to now talk about an attorney nominated as executive testamentary, because that is very important to you that's going to become attorneys and advocates now. If an attorney is nominated by name as an executor in a will, the master will appoint such attorney in his personal capacity. Do you see that? We said just previously, you're not an attorney, you're an executor. It's the difference. So you're held to the standard of an executor. But in criminal cases and civil cases, in terms of negligence, be careful. I did a lot of them. The fact that you are an attorney, the court will take into consideration, because due to your qualifications as an attorney, you should know better. So your punitive measure or penalty in civil litigation or criminal litigation will be stiffer than a guy in the street that does nothing. Be careful, be careful. If you're an attorney, accountability, the bar on accountability is set much higher. So just out of the first, that's coming up in my mind. Be careful of who you are. Although it's in a personal capacity, remember that if you do something wrong, being who you are, it's going to bite you in the ass. Right, let's go on. Excuse the pun. If the nominated executor has been exempt by the will from furnishing security, hopefully there's a clause to that effect, the master may suspend the necessity of furnishing security, usually for amount equivalent to the gross value of the assets. If, however, the nominal executor is insolvent, has committed an act of insolvency, or resides outside of the Republic for any good reason, notwithstanding the terms of the will, the master has the discretion to call for security or whatever they want to do. So please have a look at that. They go in there in the second paragraph. If a firm of attorneys has been nominated as executor in the will, the master will appoint a partner of the firm nominated by the firm as nominee of the firm. I find this very interesting because in my career I've seen when attorneys split. They're now mad at each other. They're going their own ways and they start fighting about who is taking white file. I've seen with deceased estates. The mandate, was it afforded to attorney's firm or an attorney by name in his attorney's capacity? So basically his personal capacity. So be careful. Be careful how you do this in terms of an attorney's firm. Roll out your policies clearly for this kind of work coming in. Does it belong to the firm or does it belong to an attorney in his personal capacity as an attorney, but not a firm, the juristic person? So be careful of that. I've seen those fights in my life. Then, of course, they talk about, now we are gone with attorneys. We're talking about family members, other person nominated as executory testamentary. Again, testamentary means the deceased appointed a person in his will. His dying wish is that his eldest son, Joe, must be the executor. In a case where a family member has been nominated as executor, example, the surviving spouse or child, then such family must be applied to the master. There you go. The Estate Act entitles the master to dispense with the requirement of security where the nominated executor is the parent, surviving spouse, or child of the deceased, even if the will does not exempt the person from furnishing security. And that's a clause I've been talking to a while. So that's basically important to say that to you. So usually they'll say, okay, it's fine, you don't have to give security. If a person other than the parent, surviving spouse, or child is nominated to be an executor, then unless they are exempt by will from furnishing security, they must give it. So there you are. So it's not family, somebody else. And then, of course, they will have to furnish security. So please take cognizance of that. Moving on to page 91, and we still have a full 2 hours and 8 minutes to go before we're going to stop this session. And depending on how far we get here, there'll be a second session or not. We'll see how it goes. All right, in any event, page 91, we're now going to the executive. Now, what do we know about the executive? Who appoints him? The master. Why does the master appoint him? Because the will is silent and who's got to be the executor. So that's what that's all about. In that case, and then keep in mind too that if an appointed executor is exempt or not exempt, is disqualified from being an executor, then we're going to actually fall back to dative, because we're going to have to present facts to the master to make a choice of who will then be executor if that person cannot make it. So in the drafting of wills, you'll see we teach you there, don't appoint one executor. Appoint two to assume each other, or appoint him as co-executor. If one drops away, one is still left. So this is how you bypass problematic issues in the future. The same, executor trustees, usually people go up to, I've seen people go up to 3. I suppose people can do more, but I've seen people put in 3 names for each. And usually the executors and the trustees are the same people, but in some instances they differ. So there's the executor dative in a case where there is no will, or the nominated executor in will is unable or unwilling to accept the appointment, or having been appointed ceases for whatever reason to be the executor, and there is no substitute executor provided for the will, the master will appoint a person. Whenever the master appoints, it's dative. Whenever the will appoints and he's accepted, it's testamentary. That's the difference. Go through this in your own time. Then they tell you, usually it will be a family member to nominate someone, usually, and read through that in your own time. That is fairly straightforward. Now, what about the attorney as a nominated executor dative? So before you even read further, you need to understand what dative means. So dative means that a master is going to appoint an attorney now as an executor. So let's have a look. So prepare yourself for exam questions if they want you to differentiate between testamentary and dative appointment. It is, of course, possible for the family members to nominate an attorney as executor dative for a state in question. Attorney, unless he is a parent's vice spell, must provide security. So if they want to appoint an attorney, then if they want to ask the master to appoint an attorney, then it will be a dative appointment. The LPIAF provides bonds of security to practice attorneys appointed as executor of the deceased estate. These bonds of security are granted where required by the Master of the High Court. The bonds are granted in favor of the master in accordance with the provision of the Administration of the Deceased Act. Be careful with the LPIAF. Just a while ago, I had to wrote a reference letter for an attorney in Johannesburg to vouch for her, that she's a credit worthy person and that she will be under my supervision, etc., etc. And I wrote a very nice letter to them, and it came back rejected, saying that this sentence must go in there. So we wrote a letter back and we say to the person there, I don't know if he thought it was funny or something, because my letter was quite long. I suppose that was the reason. It was 2 pages long. Because in my letter, obviously at my senior level, I included the LPIAF guidelines. And the paragraph he indicated was, in fact, the last paragraph in the letter. We wrote him a letter back, told him to read the letter, and then phoned him a couple of times. He didn't answer his phone at the LPIAF, and a bond was approved, and the letter was accepted. This is the human factor of interaction between us. So yes, so that one I've done there. It actually goes quite fast, and if they approve it, then under these circumstances you can do it. So if you have got any problems with that, you can just on the internet Google LPIAF. I found their constitution quite intact, of good standard, and the application form, it's a long application form, but it's a good application form. And then of course that supervisory letter. Now that supervisory letter was only asked why. Who knows? Who out there can say, I'm listening to you, I know. Because this is the first time ever this attorney did what? Applied for a bond of security to as a foundation for doing a deceased estate. If you do it a second, a third, or fourth time, then that letter of reference I had to put in for doesn't have to be put in. So let me just say that too before you get a wrong idea. Page 93, family member or other person is nominated as executor. They're talking about that. I'm not going to go through that with you. That's easy enough. Aha! I'm now busy with a will where the people are working in Dubai. They want guardianship. The child is with them in Dubai, but they're still citizens. I got this instruction this morning. They are still citizens of South Africa. So me and this very same attorney accepted our fee after negotiation, and we're going to do that from now. Now this means I have to look at the Dubai legislation while they're there with the child. If they die there, what will happen with the child? What does the law in Dubai say? Apart from that, and they wanted me to put up 2 wills. I'm not going to do that. I'm going to put up 1 will in which I deal with while you're in Dubai. This is the law, and this is what will happen. And then, of course, in terms of your interest and your assets, everything in South Africa, well, we're back in South Africa. I'm not going to waste the time by putting up a duplicate will. I'm just going to make certain that I do my work and research the relevant legislation in Dubai to make certain that while they're in the jurisdiction within the country of Dubai, that they adhere there to what is relevant there. And I'm waiting for information. I don't know if they own property there, but most certainly, I think they might have maybe a banking account there. We'll see. Maybe they bought furniture. Maybe they have a car they're going to sell when their contracts are over. I don't know. But this can be done. So let's have a look at the foreign letters of executive. So that's not relevant to what I'm saying, but I'm telling you, these things happen. It's going to come over your table, and you're going to have to deal with them. The Minister may from time to time publish in a gazette the name of countries to which provisions of Section 21, which deals with the appointment of foreign executors, and so on. The minister may also at any time withdraw or amend such notices. Section 21, what does it say? Recognizes the appointment of executors appointed in countries other than the Republic of South Africa. The master must sign and seal. It's almost like medieval times. Is that right, Justin? We have that red. The kings used to put that red glue or whatever you call it, wax, on a paper and chop it with this ring of. So this actually how it sounds like. Keeping my IT guy awake here. Seems he's asleep. Now he's chirpy. In any event, they got to seal and sign it. That's important. The letters of execution before such person will be able to act as executor over a South African assets of the deceased. I want to read every sentence here because we're going to speak about foreign things, and I get this question so much. In the last week, I've gotten quite a few times. What do we do about foreign executors? South African assets, but I've appointed the foreign executor. But I have especially property in South Africa, especially also in Canada. And one of them I dealt with was Victoria, the province or the state of Victoria. Because in Canada, every province has got its own legislation. It's seriously complicated. Because you've got to go to the right province to understand what they're doing in that province. It's not in South Africa. Okay, in South Africa, we don't have a codified law. We have got various resources. But our legislation doesn't run from province to province, except on a provincial level. But that has to adhere to national legislation, like your Liquor Act. It's got provincial Liquor Acts too, but they cannot contradict the National Liquor Act, stuff like that. So that is things we have to look at. I want to read every sentence to you here because people get into trouble with this kind of things. I know people in Nelstrade wanted to use me a short while ago for his deceased estate that there's a lot of money lying in Swaziland. So those are things that after COVID, they never came back to me. But this is the things you are going to be challenged with. Section 21 recognizes the sealing of it. Once the masters issues the sign and seal appointment to a foreign executor, such foreign executor shall be deemed to be appointed executor over all the deceased estate in the Republic as if such person has been appointed by the master. Before the master will appoint such a foreign executor, the following documents must first be lodged with him being the master. A duly certified authenticated copy of the will, an inventory of the property in the Republic known to belong to the deceased, and that's about the size of it. All right. So that is something I want to bring under your attention, but we're going to say much more about it because this becomes complicated when we have to calculate the state duty, taxes, etc., etc. So please take note of that. It can be done, and don't worry, you don't really need a wax, or the master doesn't really need a wax. So that is something I want you to look at. Whenever we touch on foreign things, pay attention because that becomes complicated and it also has a rebound on SARS. So these are things we have to look at. Right, on page 95, the appointment of the master's representative. I'm not going to talk about that. That's the 18-free estate. You don't have to open a bank account, etc., etc. It was 125,000 Rand. It's now 250,000 Rand. This is so easy. This is so easy. You can do it very quickly. And usually you also negotiate a minimum fee there, obviously. So that's something you can look at. I'm not going to deal with that. Then on 2.9, page 96, the steps to be taken after receiving the letter of executorship before launching the liquidation and distribution account. All right, here we go. So now the master has come back. You've been appointed an executor, but you also get your reference number for your deceased estate. And you're going to be using that now on all your letters. I don't know if there's some of you out there can get that number before you actually report the deceased estate, which actually logically I cannot think is possible. So, all right, that number, very important again, must go on all your emails, all your letters on top of your file. Make certain you write on your file the right number down. If you drop a letter or anything there, then we have a problem. Powers and duties of the executors. The executor's functions are to be taken to take control of the assets, to determine value, blah, blah, blah. What are we saying here? You now the executor. You have just walked into the shoes of the deceased. You have the same powers as the deceased in terms of what you would have done of his assets if he was the owner, which is limited to a certain extent by legislation. So as an executor, you are very powerful. And that's why you must be cautious not to be caught up in things you shouldn't. You take control of everything. You have discretion in many things, except where the law limits that. So as an executor, you have to go out and you have to do the work or appoint the agent to do it. So that's very important. I actually don't want to say anything more from that. The moment you take control, you go to the farm, you take control. If it's a business, you take control of the business, you pay the people salaries, and you are the boss until everything is winded up. You make certain that buildings and properties don't get vandalized. Vandalism. You can be kept liable if there is vandalism and you've done nothing about it. But this negligence is coupled with available resources. Most of the time monetary in its application. What does that mean? It means that if you cannot appoint a security company because there's no money and there's just so much to go around to look after the building, it cannot be your fault. That's just a simple example. But you are liable. And if you are the reason that the heirs are negatively impacted on in any way, it can be proven, then you are going to be liable for damages. You are also limited in the case where in the will, the executor's duties are set out. I never agree with that. I draft in trust in wills all the time. I love doing that. I set up your trust in your will, and then if there's minor children, for example, and the people die and there's still minor children, then those conditions of the trust in your will be transferred into a trust and the trust deed, etc., etc. But the moment you start drafting executor conditions into the will, it might be argued that he might not do anything beyond those conditions that was drafted in. I leave it open. He's appointed the executor, will run with the law and whatever happens with it. Because a lot of people don't really know what executors do and what they can do and not do. And the moment you say, but he may do these 5 things, you might be held to it that he can only do these 5 things. And then there's a serious problem. So those are things you have to think about before you do that. So there it is. Take control, etc., etc. Do the evaluations, all of that. Nothing magic happens when one dies. The rights enjoyed by the deceased prior to the date of death flow over to the estate and may be exercised enforced by the executor, and the obligations incurred by the deceased prior to death become a claim against the estate. And so it goes on. Accordingly, if one has the right of retention over assets of the deceased during his lifetime, this right remains operative against the estate, a lien or a pledge. Excuse me, nothing changes. Nothing changes. If somebody has been suing the deceased during this lifetime, it's a claim against the deceased estate. You're going to have to argue it, or you're going to have to defend it, or you're going to settle it. And usually, you don't want to fight it anymore. If you can settle it, you will settle it, except if settling it shows clearly that it will be negligent and that the probabilities is massive that you can win it and thereby benefiting the heirs. And also, this is always something as an executor I would always discuss with the heirs. Always with the heirs, in writing. And before I exercise my duty as executor, even though I have the power to do it, in circumstances that's sensitive, I'll make them sign that we discussed it and they agree with my advice. And if they don't agree with my advice, in writing that I don't agree with my advice, and then I'll maybe take another direction as executor. I'm not giving my authority away, but I'm also not going to get sued because of nonsense. There's no guarantees on civil or criminal litigation, especially civil litigation. You can be winning the fight right through to the last 2 seconds of the court case, and the adjudicating chair rules against you. And this is court cases I'm talking about. Let's think about investments, etc., etc. Wrong investments, so be careful. But yes, you have a lot. There's the notice to the creditors. In order to determine the creditors of the estate, provisions made in terms of Section 29 to place a notice in the Government Gazette, a newspaper, circulating in disgrace where the deceased was ordinary resident at the date of death. The notice advises the death and calls on creditors on the estate to forward detail their claims to the executor within a period of 30 days. Underline that. Underline that. All the days, all the periods of deceased's estate administration is very important. From date of the last publication, the prescribed form to use is this and this when you do that. So you have to do this, but you will already know who the creditors are, most of them. You still have to put the advertisement out. You don't have a choice, because that is going to protect you against personal liability. That advertisement, if this thing is winded up and there comes a creditor out and say, but hey, I don't know his debt, he owes me money, and it's winded up, everything, there's nothing left, you've given everything away. And he says, but what did you do to contact me? Did you know that this advertisement is your defense? You got to do this. And in any event, you won't be able to wind this up if you have not submitted to the master that you've done it. So go through it in your own time. All right, here's something interesting still under that heading. Let's just go to periods. Last paragraph there on the 292 on page 97. If the deceased resided more than one place during 12 months prior to death, the notice must appear in a newspaper circulated in each of the districts in which he resided during the said 12 months. As stated above, the use of a national newspaper instead of advertising different newspapers in each area is a practical alternative. So yes, where he has died in that area, or actually his residence, in the 12 months, presiding the 12 months, the stuff you have to take into consideration. All right. Then, of course, you open an estate check account. After the letters of executive have been received and you have more than 1,000 rand, unless the master otherwise directs, which he can do, usually doesn't, the executor must open a check account where? In the Republic of South Africa, not in Zimbabwe. So all monies received by the executor must be deposited to this account. No other country, not America, not China, not Uganda, in South Africa, because it's within this jurisdiction. So there. And of course, then you can, in the Feldman case, a very well-known case, you can go actually and look at the definition of money, and that we put it in here for you, because you would be surprised what is there. They say it. They look at checks and all of those, and so that is then you'll be surprised at the definition of money. All right, moving on to the next step, determine the solvency of the estate. Once the period for the lodging of claims in terms of Section 29 has expired, 30 days from the latest advert, the executor must determine the solvency of the estate. If the estate is insolvent, then you're going to pursue Section 34, and I'm sure they will talk in here. We'll talk in here about it later on how you do it, but then you have an insolvent estate. Obtaining valuations and certificate of balance. I'm not going to talk about that. Certificate of balance from the creditors, reaching out to valuators, specified valuators, estate agents for immovable properties, somebody in the antiques for antiques, car dealers for cars. Run with it. Selecting the method of liquidation. The executor's duties are to realize only so much of the estate assets as the executor reasonably and necessarily requires to create liquidity in the estate to pay the liabilities, cash bequests, and estates. Not even going to read further. What does this have to do with? This has to do with the fact that before you bequeath to a legatee or to a normal beneficiary under the residue, you first have to meet the deceased liabilities. So that's the big thing. That's actually what it's all about. So first you meet a liability. So when you have met all the liabilities, you've gone through that 30 days and nobody can lodge a claim now, even though I'm telling you this, if somebody lodges a claim later than 30 days, there's a possibility you're going to have to consider that if you haven't winded up yet. And if you have winded it up, in certain instances, it can be reopened, but it's a messy situation, obviously. So this is very important to look at. Can bequest an estate duty unless the will provides to the contrary. Section 47 provides for heirs to give the executor written instructions as to which assets to realize, and in the event they are not being unanimity or a beneficiary being a minor to the assets may be realized subject to the terms and conditions as approved by the master. So that is something you can go through in your own time and look at that and see how it operates. But please remember, the heirs get nothing until you've met all the liabilities. So it's actually not selecting a method, but I also want to emphasize, because they're saying here, it's better to do it in cooperation with the heirs. Always say to the heirs, well, guys, you've inherited this and this, but this is the outstanding debt. We can cover it with these assets. We're going to realize these assets. What does realize mean? It means you've got to sell off. You've got to sell off if you have to. And then always keep them abreast of what's happening, and as far as possible, have them agree to it. If they don't agree, you're the executor. All right? So then you have to run with it. There, look at the Schofield case. It gives you some good indicators of what you can do there. All right, so on the 2.96, one way you can select the method is also, I suppose, in specie, unrealized. Wherever possible, this method should be applied. The executor is not entitled to realize any more of the assets than is necessary to create liquidity. Liquidity also means money to spend for advertisements, money to spend to administer the deceased estate. So keep that in mind too. In terms of this method, the assets are handed to the heirs in the same form as they were held by the deceased. A testator who has done adequate estate planning should have provided for sufficient cash. Okay, sufficient cash, underline. What did I say previously? When you set up a testament, ask the people to take out a small policy where the deceased estate is the beneficiary. That's how you create cash. 150 Rand a month policy. Send them to the broker or whatever. In the absence of that, if you didn't know them and the deceased estate is coming to you, see if there is such a policy in existence. If you've come through me setting up a will for you, then I have them sign my mandate. And in explaining the mandate, I always say, I'm advising you to put up a policy, if you don't have one, where the deceased estate is then the beneficiary. And then who's the policy holder? Of course, the deceased, because if he dies, then it pays out into the deceased estate if the deceased estate is the beneficiary. So that's what I'm talking about. Even where there is insufficient cash in the estate, the method may be followed provided the heirs pay or secure the cash shortfall. Liabilities must be met. If there's a shortfall, they're going to pay in. It happens. The method of liquidation has a number of advantages. The executor does not have to sell assets. Therefore, there is no time delay for the sale and no further capital gains tax liability, and administration may be finalized a lot quicker. There may, of course, be circumstances which make the award of an asset in specie impossible. For example, you can look at the example there in terms of co-ownership under the subdivision of Agricultural Land Act, and there's an example for you. So have a look at that, and then you can go on that. Another method is the partial sale of assets. While it's desirable to award the assets to the beneficiary in species, the shares, all the shares go to you, or the car goes to you, or all the cars go to you. It might always be possible, for example, there may be a cash shortfall in the estate, or the heirs may require the assets to be reduced to cash. So then you can do that. It is a requirement of the administration that the executor pay the debts and the beneficiaries of the estate. The creditors and the beneficiaries have no right to the claims of him before due date of payment, disfinet, that's important. Although an executor's powers are wide in this respect. I'm not even going to read further because it has to do when you are entitled. It's well said out here. You are only entitled as an heir and a creditor when you're entitled. Now, as a creditor, you're actually always entitled because you can sue the deceased estate. But when you're an heir, you're only entitled after liabilities has been met and the bequest can be facilitated. You have a right to, but you're not entitled to receive. So go through it. I've seen exam questions on this. Make certain you understand the terminology. I'm sure you understand what I'm saying. The executor there's no obligation. Remember, the will says the heir can get a red Ferrari. There's no obligation on the heir until he meets the legislative final point of winding up. You're entitled to, but you're entitled to receive it until the date the law allows you to receive it. Be careful with this. There's been questions on this. Total sale of assets. A total sale of assets takes place where the will directs or in exceptional circumstances. You get this a lot. I get it a lot of my offers. No, sell everything. Divide the money between them. Then I would say, hey, stop the bus. Is there a gun or is there inheritance? Maybe a ring or something. And then they wake up suddenly. Oh, yeah. I want my son to have his grandfather's ring. But then you get a lot of people that say, no, sell everything and divide the money equally. Or, now they determine it must be divided. There I've seen horrendous things happen. And you have to fulfill that mandate. You don't have a choice. I had a testament where the deceased said to me, disinherit. my son-in-law. I said, why do you want to disinherit him? Now, the other day they came to braai here, and I had to pull the braaier to the lapa for about 5 meters. He's got no manners. I said, but you know, it doesn't work like this. He said, he's inheriting nothing. Make it clear that everything goes to my daughter. Who do you think died first? The son-in-law. So the deceased died later. Things like that. But if that is your instruction, that is something you have to do. So the principle of freedom of testation is applicable here, and the executor will be bound by the provisions of the will. This is so even if the heirs unanimously agree in writing to deal with the assets in a manner different from that prescribed by the will. The terms of the will always takes precedence. In the second instance, a total sale may take place if the estate is illiquid or insolvent. Well, then there's no choice. In the first instance, a total sale may be requested by the heirs. You cannot force an heir to take stuff. If he doesn't want anything, he doesn't want anything. I remember when my father died, my brother said to me, let's divide it equally. But in the will, everything was given to him. And I set up the will. So it's no funny business. My father asked me to do it like that. And after he died, my brother said, well, I want to give you half. And I said, no. You know, you're entitled to do it. But no, I'm good. I don't want anything. You can take all of it. You cannot force an heir to take. Now, this is maybe not the best example of that. It's just something I'm sharing with you. If an heir doesn't want anything, he can say, I don't want anything. So that's what that's about. So have a look at that. And then, of course, it goes back into the residual, the residue. And after it's been in the residue, then obviously it gets divided under the residue as indicated by the deceased. And if not indicated, then of course, remember one thing, that you might have a will that's testate as well as intestate. And then you have to deal with things in a different way. Then both acts apply. So he have bequeathed this, but he didn't bequeath the residue at all. It says nothing about it. Or he bequeathed those properties, but he didn't bequeath these properties. It's not mentioned in the will. Then both the Intestate Succession Act and the Testate Succession Act applies. Big words. We have a sip of water here. I bet you didn't know that. I said, except for the people listening to me that's been doing this for years. And then you have to apply both. Right, then taking over by the surviving spouse in terms of Section 38. They call it a Section 38 takeover. That is the terminology for that. Let's see what happens here. This method of liquidation is only used in exceptional circumstances, and as the method indicates, can only be used when the testator is survived by a spouse and there is no contrary provision in the will. This method entails the surviving spouse buying out the other heirs, normally in order to retain the assets, especially in a family home, which may otherwise have to be sold to provide liquidity or to avoid co-ownership. Guys, what is this about? This is about when you forget to put in the surviving spouse clauses. Surviving spouse gets everything. When she dies, I want my stuff to go here. After she dies, I'm dying if I die first, and other stuff to go there. Her stuff she will deal with on her way. So this is very important. I've seen this happen where people put up a will, and it's the intention that when the first one dies, the second one stays in the house with the furniture, with the cars. But I don't say it. But I appoint heirs. The children takes this, that, and that. This is when this happens. That's one of the examples when this happens. And I've seen it so many times that surviving spouse clauses are lacking. They don't talk about if the second spouse dies within 30 days or 60 days, etc., etc. And do you know where I've seen this in a heartbroken situation? When they don't change the will after they're divorced, you get that 3 months period. They don't change the will. Suddenly the ex-wife walks in, and they never changed the will, and she dominates the platform. So guys, when you put off a will, you've got to ask the right questions. These people that come to you seek your advice. You're becoming an attorney now. Some of you are youngsters. Some of you were administrators, which is great. It's just a new title and you're going to make some good money. But the youngsters must understand this. There's so many questions. And I see now also with the code of conduct, because I have to utilize that in educational manuals, I've also seen that there's a strict liability on me and you not to be negligent and to say to the work no if we don't understand the work. So be careful out there. You can get sued and it can wreck your practice permanently over quite a while. So go through that, have a look at that. I'm not going to talk too much about that. A surviving spouse buys the estate assets or a portion thereof, a valuation acceptable to the master, and pays for the assets to be taken over in excess of the survivor's entitlement and cash or secure such payment to the satisfaction of the master. It happens. The amount, if paid in cash, is paid into the estate, is then used to pay the other heirs and creditors. Although it is not a sale in the normal sense of the word, the result is the same as far as the other heirs and creditors are concerned. So in another setup, the heirs can deal. If the executor is amicable, the heirs can talk to each other. Mother, left me this painting for 1 million rand. I don't want that, but I'd have that car. I know you don't want that car. So the executor is in control and he can set up those agreements. The concept of major heirs and creditors is a prerequisite to the application, which application this requires the consent of the master, and that's what I want you to underline. So in the Section 38 takeover, it's within the discretion of the master, and he will have the final word of it. And one of the criteria he will be looking at is malafide intentions. So if the intentions are bona fide, that's fine. But if there's malafide intentions, he's going to have a problem with it. An application of Section 38 takeover is made by way of an affidavit, underline that so you know how to do it, by the surviving spouse, which must be signed by such spouse personally. The executor confirms the application by signing in his capacity as executor. This is not necessary with the spouse is also the executor. The application must deal the reasons for taking over. Why has this been done? And I've given you an example of one of the examples this can be done. They will, of course, depend on the circumstances, but normally one of the most important reasons is to retain the family home, where the estate is illiquid, and the home would otherwise have to be sold to provide liquidity privately or on a public auction, or what the situation is. And we also give you there in Section E, there's a precedent that you can use to enforce yourself. Right, and then I would also take note of the fact that your Section 38 takeover has got nothing. It differs from your redistribution agreement. So just also have a look at that. And then they go in to explain the massing of the fideicusum. I'm not going to talk about that. You distant learners, a lot of research depends on yourself. Go and look at that. You will be granted the opportunity to ask me questions. All right. If you have a question, there will be opportunity that I will be brought back to this institution to answer questions. So don't for a moment think we're leaving you in the dark. They're doing everything possible to make distance learning as easy as possible. Also taking into regard the restraints of this pandemic the world is under. Let's quickly talk about redistribution agreements. What's the time now here? The time is not relevant to you. I think what I'm going to do before we go on, let me just see if I can get to a major heading. Yes, I'm going to go to the major heading, and then for 5 minutes, which will not be 5 minutes with you, we're going to stop, and then I'll be immediately back for you, but at least my voice will have a 5 minutes rest. On page 103, what is a redistribution agreement? In the past, we didn't used to have them. Redistribution agreements are common. Most times they are informal, but where immovable property is involved, a redistribution agreement must be formalized and liquidation distributed and drawn accordingly. An example of an informal redistribution agreement is where indivisible assets such as furniture, motor vehicle, jewelry are left in equal shares to the children. Generally, the children conclude an informal redistribution agreement as to who takes what. This is brought to account in the final reconciliation statement. If, however, movable property is involved in a formal redistribution agreement, must be concluded and attached to the liquidation distribution account, and the distribution and drawn accordingly. Failing this, a conveyancer cannot sign a certificate required in terms of so-and-so of the Estate Act. What's that about? That is re-registering the immovable property for the deeds office, through the deeds office. And that is all what that is about. The amount that each heir is entitled is fixed either by a will or interstate succession. An adjustment of the amount that each or any of the heirs receives will amount to a sale or a donation. What we are concerned with here is a reshuffling of the assets resulting in a redistribution of the assets, obviously where there is no contrary provision in the will, so that the value of the legacy or inheritance to the beneficiary remains constant, but what each beneficiary receives in making up the value of his legacy or inheritance is redistributed. So we want to retain the value. He's got to get R250,000. He's got to get R250,000, and no, he must get 150,000 rand. So we're looking at values, we're looking at valuations, and that's also why a redistribution agreement has to be signed, because we don't want any comebacks later on. Yeah, but I was cheated, blah blah blah. So the road is long. The executor must do the valuations. They must have meetings with these people, and it must be done correctly. So there you are. I'm not going to go further. Just have a look at the Agricultural Land Act. That's always an issue. And then I talk about the fact if everybody has majors and when there's minors, it has to be held in trust or whatever the situation is. And then the last paragraph there I think is rather important. Creditors may not be, this is very important, creditors may not be party to a redistribution agreement, NB. An accrual claim is that of a creditor. So there you have it. However, a person married in community of property, MICOP. MICOP means married in community may be a party to the redistribution agreement. And then for further information, they refer you to the Marchowitz Guide as a source. You'll see in here. You can go read further on that. And you're a distant learner, so a lot of research you have to do. So please remember this. I have seen people make that mistake. Not a lot. Most people understand that the redistribution has got nothing to do with creditors. But a one day on accrual might wake you up a little bit if you didn't know what's happening there. All right, then we get to the sale of estate assets. When we get there, we're already getting close to the end, because we have set out the things in the liquidation of this distribution account. We have done the valuations. We've spoken to the heirs. We now have to look at what we have to sell or not to sell. Are we going to sell to get liquidity? That's in the beginning. But if we are liquid, then we're going to have to sell things if, for amongst others, there's instruction of the deceased in the will. Up to now, quite a few references have been made to the sale of assets by the executor. The question arises as to how the executor must proceed to selling the assets of the estate which are to be realized. Please make a note there, especially for you younger guys that's just come out of college, university. You might know what it means, but when we realize things, we sell them. We turn them into monetary value. So that's money. There are basically three ways we can sell things: public auction, private treaty, or public tender. I've seen this in the exam before. Be cautious of this. Section 47 of State Acts important in respect to the sale of assets. Candidates must take note of the contents of this section, which have been held to be preemptory. See also the important provisions of Section 49. Another important section in the Act is 42. Requires the executor to lodge with the Registrar of Deeds a certificate by the master to the effect that there are no objections to the transfer of the movable property. I'm going to stop there. That's all I want to bring under your attention for conveyancers. The master must issue a certificate that the deeds office can do the transfer and register it. All right, and then of course the Faria versus Sheriff, I think I'm also going to deal with. This is more my line. When you're caught, you're fighting about this. I used to do it in the past. As regards the sale of property in terms of Section 30, immovable property attached in execution, even with an order declaring the immovable property executable, may not be sold without a subsequent specific court order in terms of the section, so be careful of that. Right, then I talk about removal executors in Section 4. Have a look at Section 4. There's your court cases where removal executor was refused. So go read those court cases. When I teach you where it was refused, then you know when it will be allowed. Have a look at that, and then they look at the concluding remarks. All right, guys, it will not be a break for you. I'm just going to take a 5 minutes break for my voice. It will not impact on you, and this recording will just go on. It will not stop. Just ask my IT guy here to pass it. All right. Okay. He says he cannot do that. I still have an hour and a half to go. Otherwise, you've got to paste them together. Well, I guess I have to go on. All right, guys. Just not lose my voice here. What is estate massing? Always a question. Most people don't know what estate massing is. The concept massing as discussed here refers to statutory massing in terms of section so-and-so of the Act. And it does not include a common law massing that you used to know or you knew about or you know about. Massing amounts to two or more persons massing, joining or lumping together their estates or a portion thereof, and then bequeathing the joint mass estate of both the deceased and the survivor to an heir of heirs nominated in a mutual will subject to the survivor obtaining a benefit from the joint massed estate. On condition that the survivors ideates, the administration involves the joining of the assets and liabilities of the survivor in the administration of the deceased estate, which are then jointly bequeathed to the heirs as though the survivor has died. There is a rebuttal presumption against massing. So there you have it. That is what massing is. In order for massing to present all the following requirements must be met. There must be a mutual will expressly providing for amassing and joining the respective estates. It's got to be drafted in. I must admit you don't see it in a lot of wills. A bequest of the joint assets of the deceased and the survivor. A limit, of course, bequest of joint assets is important, underline that. A limited interest which must be created in favor of the survivor, and the survivor must ideate, accepts the condition of the mutual will. So those requirements must be met. Please, we have typed in the ideation means acceptance. Ideation, repudiation. Repudiation means I don't want it. Ideation means I accept it. Please make a note there. A lot of people, when they read the word ideate, for some reason in the brain, it registers, no, I don't want it. Ideation means accepting it. Repudiation, as you will see later on, means it's fine, I don't want it. I repudiate it. There is a presumption against massing, and therefore the clause in a mutual will creating the massing must be drawn clearly to ensure that the intention is to create a massing and for the presumption not to apply. For an example of the problems that can be encountered where clauses dealing with massing are not drafted in a clear and ambiguous terms, you guys can go and look at a Rhodes case. But meet the requirements, and there you have it, massing. Understand ideation correctly for what it is, and strange enough, people don't have a problem with the word repudiation. But most of the time, if they see ideation and repudiation in the same sentence, they're fine. But if they see ideation alone, they actually don't amount it to accepting. So that's interesting. Limited interest in a mass estate, they want to talk about that too. In order for a mutual will bequeathing joint assets to be valid as regards massing, a limited interest must be created in favor of the survivor or the assets of such a survivor as well as over the assets of the deceased. That is why this whole thing must go through ideation. The survivor must accept the conditions of the mutual will. Now, strange enough, if you draft it correctly, then the clause will indicate it automatically. But people don't do it because drafting these clauses are actually difficult. If you just draft something wrongly in it, then it's not going to work out. By limited interest, it means a usufruct. You all know what the usufruct is. Enjoyment of the fruit, lifelong, things like that. Fiduciary interest or income beneficiary under a trust. If a limited interest is not created, it will not be a massing but an election, but will result in a donation by the survivor. So that is what is important there. And that's why the drafting of the clause is so difficult. Massing entails the survivor bringing assets into the estate of the deceased and bequeathing them together with the deceased assets to the beneficiaries named in the mutual will. And I want you to write in there, don't stop the sentence, while the said survivor is still alive. All right, do you understand now what this is all about? That's why the said surviving survivor have to do the ideation. And that creates a limited interest. All right, so there you are. This means that the survivor's assets are awarded to the beneficiaries while the survivor is still alive. Okay, you don't have to write it in there, it's in there. In return for this, the survivor obtains a limited interest over both his or her own property as well as over the assets of the deceased. And I'm telling you, this happens a lot if a will is not correctly drafted. You can draft massing because people want it. They might not feel if they die that the surviving spouse is going to do weird things they don't want done. people are worded in this way. So that's also why this is then exists. Massing is especially popular where spouses married in community of property want to benefit the children, but at the same time want to provide for the maintenance of the survivor of them. By massing their respective half shares of the estate, the community estate is bequeathed to the children. Instead of becoming entitled to half share of the community estate due to the dissolution of the marriage by death, the survivor obtains a limited needs, normally a usufruct, which is the use of the fruit of the house until she dies, and that will be registered as a usufruct over the property at the deceased estate. Yeah, well, you know, I'm not too fond of it, I have to admit. I see many problems with it. I can see that she can still be thrown out of the house if it's lost. So I'm not going to say too much about that. Massing is also a useful tool in the drafting of a will, where spouses of a second marriage wish to ensure that the survivor benefits, as well as the deceased children from a previous marriage and a marriage of the current children. That I've seen before. Massing is also a useful tool in the married in community of property to give effect to the party's intention to bequeath specific assets to specific legatees. All right, I suppose at this stage I must just explain to the newcomers what a legatee is. A legatee is easy. It's the easiest thing under the sun. I bequeath to you 12 Rand 75. I bequeath to you my Ford Bakkie model so-and-so, color so-and-so, with registration number so-and-so. That's a legatee. A legatee, in short, is something that I bequeath in specific. So that's basically what that is all about. All right. All right, then we have adhesion or repudiation. I'm not going to talk about that now. I've spoken about it. I'm going to skip that. And then, of course, an adhesion repudiation certificate and a mass estate must be contained the following. If the surviving spouse then adheting under this massing, that certificate must be issued under the following circumstances. An express declaration that the survivor is aware of his right to adheate or repudiate the terms of the will. A declaration that the legal implications of adhesion and repudiation has been explained to him and that he understands the consequences of adheting and repudiating the terms of the will. A declaration that with full understanding of the right to adheate, repudiate, and the legal consequences of adheting and repudiating the wishes to adheate or repudiate the terms of the will. A brief reference to the provisions of the will in which the massing has been created, as well as an exposition of the assets subjecting to massing or then a consent to it, if it's not in the will. Acknowledging that the decision once made is final and cannot be changed. A signed declaration by an attorney at the end of the certificate in which it is stated that the legal consequences of adhesion and repudiation has been explained to the survivor. Do you see where this is going? It's dangerous. The adhesion and repudiation certificate must be signed by the survivor in the presence of witnesses. And I'm going to leave it at that. You guys can in your own time peruse through that. I think you've enough information as a platform from which you can project your research and further distant studies. Then we talk about the provisions of Section 37. Section 30 says that a beneficiary should obtain the same rights in respect of the survivor's property as they would have had if the property belonged to the first dying. In other words, although the survivor is still alive, the beneficiaries obtain ownership in respect of the survivor's property, and that, ladies and gentlemen, is why I don't like it. That is why I don't like it. Because there's nothing there's so many things that the new owners can do that can actually create a situation wherein the usufructuary loses her usufructuary rights under the situation. I'm not happy with this. I'm very cautious when I draft things like this. I fully explain it to people and what can be the ramifications of it. It's very difficult. It is true that this usufructuary right is registered over the property at the deeds office. I'm just not comfortable with it. You never know what happens. It is protected in law, but estate duty amassing, bear in mind that estate duty is only leveled in the estate of deceased. For this reason, the property of the deceased and the property of the survivor must be specified separately on the account, especially where the parties were married out of community of property or not married at all. All right, that's easy enough. Where the parties were married in community of property, the assets of community estate will in any event be reflected in the account. The reasons the assets must be specified separately is to facilitate the calculation of estate duty. Just right there again, 20%, since duty is only payable on the deceased estate. Please look at it. You will not believe how many times we get this question. Well, do we pay now the estate duty on the surviving spouse too? And then the next question is the common estate. So these are the questions we get. So look at that and understand what you are doing. Requesting an extension for the lodging of the liquidation and distribution account. I'm not going to talk about that. I spoke about that in the beginning. I'm skipping it. There's the way you can do it. 6 months, do you recall? I said that in the beginning. So there that is. Then drafting the liquidation and distribution account. Now, here we're going to have to go a little bit slower. And I'm happy in this session where I have an hour and 50 minutes over. I wanted me to finish this, but this is too complicated. I'll try and convince them to come back tomorrow again. The drafting of the liquidation distribution account. It starts off with a heading. It starts with all the information of the deceits. It goes through its subdivisions. Always keep them the way we teach them. Listen to me. The way we're going to teach you, keep it like that until you experience, and then you can start mixing them around if you want to. And then, of course, before I go on, the next question is how many columns? 2, 3. You can select, but keep it in the manner we're teaching you until you have experience. If you have experience, you're just becoming an attorney now. A lot of administrators becoming attorneys, people that used to do this for a long time, and they decided to become attorneys now. They'll know why I'm saying this. So, and follow the calculations meticulously. To balance a liquidation and distribution account is sometimes one of the most difficult things to achieve, especially if it's out with 1 cent. Strictly speaking, it's not necessary that it should be out with 1 cent. Use creditable calculators. Be careful for going into decimals behind the comma. These are the things that can throw your calculations out. So be careful in that sense also when you calculate percentages. And here's an interesting piece of advice. Work with 1 calculator. Don't work with 2 calculators. Especially if you have these cheap ones and you have these expensive ones. Because the expensive ones will throw out one hell of an answer for you with decimals, where your cheap calculator won't do that. Do you see what can happen if you work with different calculators? You can pick up a problem with that. All right, let's start. In terms of Section 35 of the State Act, an executor must lodge an account of his administration with the master within 6 months of his appointment, or within such extended time as allowed by the master after application has been made in terms of Regulation 6. All right, so I'm going to jump this. There is your liquidation and distribution account from the beginning of the end. Your heading. Now your heading is liquidation and distribution account, but this is not the heading they're talking about. So what you have to do is your first heading is liquidation and distribution account, and then your main heading that could also say liquidation and distribution account of so and so. After your heading, decide on your columns. Usually, you have a first column with itemized number and then money columns. You can have a first column if you want to have chronological order numbers also of items you're typing in. People don't really do that. They put in the information, they have an itemized column number, itemized, because that number is going to be compared in later calculations where you will say, for example, under the assets, farm, itemized number 1, and later in other calculations, you're going to say 1 plus 2 plus 26, multiply this is the answer. That's going to be the purpose of those numbers. For now, they might run 1, 2, 3, 4, 5, 6, 7 in your immovable and your movable assets. But later in the calculations, they taxed in different ways, and you're going to use those numbers to indicate where this information is coming from. First column will show you, second itemized column, and then money columns. And you can have a first column if you want to, for your own personal reference. We'll see what I did in here. We'll get to that. So you're heading, then you work out your money columns. Are you going to work in 2 columns? Are you going to work in 3 columns? Or are you going to work in 1 column and build in these individual calculations into the 1 column? Not a good idea. 2, 3 columns, great. It depends on how you want to do it, except if you have software that manages. Because you know, if you have software, you just type in the calculations, software spits out the calculations. Then you're going to go into your liquidation account. We're going to talk about that. You're going to go into your recapitalization statement. You're going to go into your distribution account, income and expenditure account, fiduciary assets account. And here's a tip for the exam. If you do your fiduciary asset account, I always give a mark for 0. And if you write under your fiduciary assets account, NIL 0, please put zeros in the columns account also. A lot of people, if there's no fiduciary asset account, they don't even mention it in the liquidation and distribution account. And usually there's marks allocated for that. And usually some other people would say fiduciary asset account, and there's none, they skip it. They don't write 0 and they don't put in the zeros. That's always a mark. Then your estate duty account, where you're going to do your 20%. You're going to also there look at your 3.5 million rebate. We're going to be looking at that. And then, of course, your certificate by the executor, a specific manner in which that is done to facilitate your discharge so that a master can file that filing notice to say we finished here. Now, that is your whole. That is your heading. Look at it. That is your heading for your liquidation and distribution account. Now, the clever guys out there, luckily I'm the dumb guy, but the clever guys out there, they mix this up, especially if they go lower. Don't do that. Do what we teach you. And if you are well experienced later years, or you're one of those administrators that's well experienced now becoming an attorney or an advocate or whatever, then okay, fine. But for the youngsters, they don't muck around with this. Because I have seen for 3 days standing teaching in a hall with 100 people sitting in front of me that everything goes, I start with wills, I take it through, I flow it into the liquidation distribution account, and in the last 4 hours I'm saying, all right, you've got 4 hours, here's the facts. Set up a liquidation account. When you finish step up forward, I've got a red Cokie pen. From A to X is your mark. X, of course, is a death penalty. And you can even get the 8 triple pass by me if I'm really impressed. And I've seen people crumble under this thing because they try to do their own thing. Okay, let's do it. I've got about an hour, let's see, on my time, hour and 8 minutes to work with this. All right, the heading. Regulation 5.1a provides for the heading to the account and states what information must be provided in each case. The requirements of the regulations must be strictly adhered to, failing which the master will direct the executor amend the heading. Do you see that? The role of the matrimonial property regime applicable to the deceased and the surviving spouse is especially important in determining ownership of matrimonial assets, as to the inclusion or exclusion of same in the liquidation distribution account. Now, in normal English, everything has to go in there. The date of death, ID number of the deceased, full names. You can put residential address in there. The more the better. Are they married in community of property? Are they married outside community of property? And is it with or with the accrual? And please, I don't see that saying here, maybe they'll say it later, we'll see. If you now really want to lose marks, don't put a reference number in there of the deceased estate. So when you have typed in this heading, right below it, before you go to the next heading, still the heading of this deceased information, you write deceased estate reference number, and you put it in. That's a full mark in exam. So usually this heading alone sets you up to 5 to 6 marks. And ladies and gentlemen, take my word for you. If you mock up this liquidation distribution account, that 5 to 6 marks you cannot lose. You make your marks there, and you make your marks at the end. People lose their marks here and they lose their marks in a certificate where they could have picked up 9 to 12 points, marks. Please, to mock up this thing is so easy. But there, the heading and the certificate, come on. Come on. You can get full marks there every time. So I'm helping you. I know where the problems lie because I marked the exam papers. Right. From the canons of this sub account, it is clear that the following information must be furnished in the heading. Let's see if they have it right. The account is described in the liquidation and distribution account. Let's see what they do here. Let's see if we can catch them. The ordinal number, first, second of the account must be stated. let's just see what I'm doing here. They still, yeah, okay, that's fine. When the interim account, which is not the final account, is lodged, it will be the first account. Okay, that's fine. It can be interim account. Then you say it's an interim account, you may do that. You can have an interim account, you can lodge it. And later you can lodge a final account. When a final account is lodged at the latter state, will then be termed as the second and final account. Look at the words. First and interim, second and final. Whether it is a final account or a supplementary account or an amended final account, maybe there was a query, go through that. The state the full names and surname of the deceased. State the identity number of the deceased. State the date of death of deceased. It seems all here. State the marital status. Be careful with that. If it's out of community property, we want to know. Is it with or without an accrual? If the deceased was married at the date of death, this must be stated. And if a married record, whether the marriage was in or out of community property, so you got to tell it. If he was not married at date of, because he was not married at date of death, we need to know it. If the marriage was in community property, then you run with that. The full names, the identity number, allocate, surviving spouse. Look at that. All of it. It's a massive heading. If the marriage was out of community property, you got to talk about the accrual. If massing has taken place, make a note here. If massing has taken place and the survivor is ideated, it must be stated that it is the massed estate of the deceased and person who has so ideated. And I can tell you now, if this is ever asked in an exam, I've never seen it before, people will lose marks here. And then the last one they throw in there, yep, it seems these guys did the job. We're happy with that. Master's reference number, very important. Ladies and gentlemen, that's the heading. Full marks in the event that you're going to muck up the rest. And it happens a lot. Documents which may be of some importance. I'm not going to talk about it. It's only a waste of time. That is documents that we have spoken of before. I don't want to get into that now. So I'm just going to move on. Now, the money column. Now, I like what I say here. Should you wish to have 3 money columns or more, just do it. So decide what you want to do with this, because you have interim calculations. Some of the calculations you even do in the information column, which you don't have to do if you have 3 columns. So if I'm an examiner and I have to mark your paper, I don't want to go and look at calculations in the information column. I like to know where my money column sits, and it goes like this. The moment that examiner has to start looking for calculations and amounts, that's where you lose the marks. And then you want to query it later on. Don't do it. So decide what you want to do there. It's up to you. No less than 2. That's what I'm telling you. Don't work everything out in a single column. Nobody does it. Nobody does it. All right. So decide what you want to do there. But I advise set up 3 columns so that under the pressure of an exam, you don't confuse yourself. And maybe in practice, you want to keep it like that. Now, that is the money columns. All right. Now, we had the heading. Now we're moving to the second division. Each heading is the liquidation account. The liquidation account marks up the most important part of the account, wherein all the assets and liabilities, movable and inmovable, shares, everything of the deceased as at a date of death are set out in detail. Please underline as at the date of death. Remember, his money can accrue interest, etc., etc., etc. There's calculations we're going to do in other divisions to deal with that. At date of death, liquidation account. Please don't build any other stuff in here. Because the clever people listen to me say, but I'm there, I can do this. Man, I'm shaking your hand. But most people get confused. And they forget that there's stuff in there that was not that date and death, and we have to deal with it in another manner. Calculations for a lot of things. So those are things that's important. So please, the sub account reflects the gross value of the assets at date of death under the subheadings immovable property and movable property. So you have subheadings. It's easy. So the heading is what? The liquidation account. What do we want first? All the immovable properties. Be careful with the descriptions. They have to be according to the deeds office, even spelling mistakes. And when you are finished with all the houses and all the farms and I don't know what else, even movable, All of it at a date of death. Then we deal with the movables. Cars, shares. Shares is a movable. Corporeal and incorporeal. Do you understand? All right. That is easy enough, ne? Got to go slow with this. In practice, a third subheading being claims in favor of the estate reflects the liquid movable assets such as money, bank accounts, life insurance proceeds payable to the estate, IOUs, and acknowledgements of debt. The liabilities of the deceased are dealt with under the subheadings of the administration expenses. Creditors, maintenance, contingent claims, and estate duty payable by the estate. So, even movable, and then claims in favor of the estate. Note that assets over which the deceased enjoyed a fiduciary or usufructuary right, including life insurance policies, where there are named beneficiaries, are excluded from the liquidation section. Remember what I said about fiduciary assets, right? Null there or stuff like this is going to go in there. Make a note of this. So far, it's easy. Heading, liquidation account. Let's fold up the liquidation account. Immovable property, movable property, and claims in favor of the estate. Don't forget claims in favor of the estate. And then I talked there about the gross value of estates, movable property description. All movable property registered in the deceased name must be reflected in that. The description of the property must be precise. I say that. If the description of property has changed, both previous as well as the current, a description of the property must be furnished. Better make a note of that. The value at which the property is reflected will depend on the method of liquidation. If the property was sold by the executor during the course of the administration, the gross proceeds of the sale must be reflected in the liquidation account, so he sold it. We know what it sold for. But of course, if it's made in another way, it's going to be either on an agent or a municipal valuation. I'm not going to talk about it any further. That's easy enough. But if you have sold it, I get that question a lot. Is it now the valuation or is it the selling price? If you have sold it during the administration, then obviously you put that in there because you're going to work out tax on it, right? All right. Where minors, absentees, or honor heirs are involved or estate duty is payable, a formal valuation must be obtained. Just have a look at that. When minors are involved, they are much more stricter. Have a look at that. If the deceased owned immovable property on which a bona fide farming undertaken is conducted, just look at that. And there I talk about 30%. In the estate duty schedule, 30% is deducted from the fair market value, with effect from 2006, when calculated due to the condition that a property is not realized. That means the property was not sold. All right, that means the property was not sold. If it is sold, it's fine. Just put that price in there. All right, so these are things you have to look at under each asset or group asset saved for cash proceeds from the asset realized. The executor must state the manner he intends dealing with it or divesting the estate of each asset. And then it goes on there. All right, now have a look at page 114. I'm a little bit upset because they didn't give us, for your convenience, an example of a heading. Oh, they did. Look on page 110. Let's quickly read it. The liquidation must reflect. Oh, they didn't do it. All right, they didn't do it. You know what you can do? Ask a question. When I come back, I'll bring one of mine. I'll read it to you if you want to. Most probably you don't want to because they told you what to do. But it's a pity they don't give it as an example. Maybe later in the book there is one. Okay, and 115, there it is. You have your immovable property. You have your movable property. And I'm going down here. Voucher numbers, divestment notes, examples, and all right, so they just explained that. All right, there you have an example how immovable property on page 115 should be explained. Have a look at that. Please have a look at the movable property. Movable property includes all things which are not immovable. That's normal. The movable assets must be accurately and concisely described. Once again, the method of liquidation which will depend on which value the property will be reflected in the liquidation account if sold in the course of the administration, the gross realized value. What it's sold for. Easy enough. If it's not been sold, it's going to be transferred over, then a valuation value. It's actually easy, isn't it? So easy. You sell it, you put that amount in. You don't sell it, you put a valuation in there. Stop asking questions about it. That's as easy as that. Examples of movable asset administered in the estate include motor vehicles, where the vehicle is sold in the course of the administration, the money. And they give you an example there. Then furniture and personal effects. These assets can be given an inclusive overall description. This can be a problem. Each item need not be specified. This can always be a problem in terms of valuation. You know, how do you evaluate all the forks and knives and the furniture in the house and all of those things? So that can be problematic. Just excuse me for a second. I don't want to put this recording off. That is not a problem. We're all human. That's it. All human. Just a little bit of sinus there. Must be the aircon or something. Hopefully. All right, we're all human. So that's that in. All right, so have a read through that. Yeah, that is done there. Furniture and personal effects. I give you a divestment no there. Then I talk about shares. When dealing with shares, one must distinguish listed shares quoted in a stock exchange, shares in private companies. They talk about specie, the transferability of shares in private companies. Have a look at that and always remember that shares falls under movable property. All right, so that's important. You can have a look at there. Then they give you an example. If shares are valid by an auditor and approved in an amount for 100,000 but sold in the course of do you see that? If there's a valuation on shares, but you sell it, the selling price is what goes into the liquidation distribution account. I want to make this as easy as possible because I'm not in front of you. If I'm in front of you, we've got boards and we write and we do exercises, but COVID doesn't allow us to do these things. So we are doing it like this. And there I set out quite a few examples for you. In your own time, please work through those examples. I just want to look at life insurance policies with you. It must be borne in mind that only life insurance policies which are paid to the estate are reflected in liquidation account. So that's what we've been saying. Policies which pay directly to nominated beneficiaries are not reflected in the liquidation account, but are reflected in the estate duty account. Interesting, eh? All policies of assurance on the life of the deceased are deemed to be property of the deceased at date of death, and where there is a nominated beneficiary, the proceeds are brought to account for calculating estate duties. Now, nobody knows this. Most people think that it doesn't, you know, if they teach you, they say, if the deceased estate is a beneficiary of a policy, then it goes, if it's not, forget about it, it's not a problem. It goes to the beneficiary. You've got to put it in his estate duty account, all right? Because he's passed it on, right? Okay, so that's something you must mark. People get that usually wrong. It may sometimes happen that an insurance policy with a nominated beneficiary is ceded to a bank or instituted in security tatem debete. The question arises as to whether or not such a cession invalidates the nomination of the beneficiary, and in Moonsamy, the court held that a cession of such policy does not invalidate the nomination, and that the insurer was justified in paying out the balance of the policy to the nominated beneficiary. These are the court cases you get involved in, so have a look at that for us. Then I go into more examples. Cash assets. The deceased may have operated various bank investments, saving and current. The capital value of the investment of each account as a date of death, together with the interest accrued to date of death, must be reflected in the liquidation account. Please take note of that. Calculated up to date of death. A certificate from the institution dealing these amounts as a date of death must be obtained. Please bear in mind that only the balance at date of death, including accrued interest at the date of death, must be included in the liquidation account. Interest earned or expenditure incurred on the account after date of death will be reflected in the income and expenditure account. And remember, if that is interest that you are bringing in as executor, how much do you get paid on that? 6%. Do you understand now? The 3.5% is on the gross value of the estate. Where do we determine the gross value of the estate? Under liquidation account, right? So that is 3.5%. 6% is on what you've brought in under the expenditure and income account. So if you're an executor, you can get paid twice, 3.5% under that account and 6% under this account. All right, just rewind, then you'll see where it fits in. So that's what that's about, eh? Because if you were to put the income running after his death until you wind up, also on the liquidation account, and you calculate your 3.5 there, you're actually losing money. But let's say you calculate it there, but you put what has come in where you should put it under the income and expenditure account, and you charge 6% there, might be theft and fraud, right? Might be theft and fraud if you duplicate that process, because 3.5 of the first plus this is what? So be careful of that. All right. Hopefully you are all accountants. Then I give you more examples there. Voucher numbers. Okay, I want to talk about voucher numbers. Each asset or group of assets which there must be a voucher is identified by consecutive numbers, which appears in the parentheses, brackets, next to the money column. The voucher may refer to one asset or a group of assets. So, let me just turn this over. Here you can see it. You see it on page 170 and page 119 and page 118. Do you see it's in brackets? All right, so that's what I mean with that. All right, so we're happy with that. Then divestment notes. We always give a mark if you indicate this is a divestment note. In terms of this sub-account, the executor must state how he intends dealing with or divesting the estate of each asset or group of assets, other than in the case of cash or cash proceeds from asset realized. The divestment note may appear after each asset or after a group or even after the end after the asset has been recorded. So then you can tell there, are you dividing it in half? Is it going to decimum, heir? What are you doing with it? So divestment notes are important. Here I give you a description of one. That Opel divestment note, above vehicle to be transferred to Peter Elliott in terms of clause 3 of the will. Very nice, understandable. We all know what is going on there. Then I have a note here. Take note that the divestment note need only be included where a property is being awarded in specie. All right. So we're not selling it. We're not sharing it. It's in specie, and the regulation provides that divestment note need not be recorded where assets comprise cash or proceeds asset which has been realized. So please take note of that. Then we go on to the liabilities. All right. Let me just page back, because I want to repeat myself as much as possible. All right, I don't need to page back. You have the heading. In the heading, there must be a lot of information for a lot of marks. When you finish with your heading, and remember, if it's an interim or a final one or an amended final one, in the heading, don't forget your reference number. Type it out, make certain you've got everything there. Great amount of marks in the bank during examination. Then you have the liquidation account. Under liquidation account, even movable, which is great. Movables, a little bit difficult. We deal with every kind of movable you can think of. Private shares, shares on a stock exchange, motor vehicles, a lot of things happening there, a lot of examples which we have given. In the liquidation account, you already start with your itemized coding in the parentheses, meaning in brackets. Then you have your divestment notes. You say what we're going to do with each of those things. You can type it in. What amounts do we put into that column? We put the valuations in. If we haven't sold the assets during the winding up process, we're winding up now, it's not sold. Valuation amounts, period. No argument. But if we have sold some of the valuation, some of the items, the assets, we put in the selling price to put it in good English, understandable English. We build in there. Otherwise, we're going to muck ourselves around with the SARS. We must defraud SARS, or if we don't defraud SARS, we might negatively impact on the heirs in terms of what they get out. So these are all the things you've got to think about. All right. We're going to use no less than 2 columns. We're going to deal with a lot of things. We're going to indicate legatees. We're going to look at cash. A lot of things we have to do in the liquidation account. All right. Let's move on. Now we are going to liabilities. Liabilities on page 120. Liabilities can be grouped. Well, what's it now, Justin? 2:15. Yeah. Okay, I'm just going to go in for a couple of minutes. I'm just going to do liabilities, then we'll stop here. All right, guys, I'm going to stop here. Justin, please come and stop it. Okay, ladies and gentlemen, I'm going to organize another session where we will start with liabilities. So just make certain that it's 2:15 now.
No, it's kort voor. Dus 2
All right, so the hiding is verkeerd. It's 2 o'clock. All right, I'm not going to start with liabilities. I'm going to go back and I'll come back tomorrow. See if I come back tomorrow. I don't know when you're going to get this, and then we'll deal with this further. And then, of course, remember, if you have questions, you can ask it. And please, you are a distant learner, start doing the research. And the best way to do research is through templates. Go take old liquidation and distribution account and come and when you listen to this recording of mine, already have a finalized liquidation distribution account beside you. And as I'm talking, you say, oh yeah, this guy didn't do it, this guy didn't do it. And that is how you learn. All right. Okay. Now, please, wills and estates and bookkeeping, attorney's booking, is the two subjects people usually fail because they're difficult and the calculations are difficult. And it's also difficult to teach these calculations to you in this manner. But I'm sure that if you rewind and listen, that it will become easy. And it is actually easy. So I'm going to do another recording that will also be placed on the eLeader platform. And I'll go and organize that. It was a privilege to sit here in the studio in Sunnyside, Pretoria, and do this with you. And I hope that you will benefit from this instead of having nothing. So that's what that's all about. Thank you very much, ladies and gentlemen. I'm getting out of here for today. And the IT guy is going to stop this now in his tracks. Have a good evening.